Lordship,
Yes.
I would like to mention item number 8 and 9.
8 and 9.
Yes, Your Lordship, may I kindly take up this matter tomorrow, Your Lordship. 8 and 9. I've taken the consent of the petitioner.
My lord, here I am for the appellant, my lord, in item number 9, my lord.
Yes.
My lord, tomorrow I'll be having some personal difficulties. May I pray this matter may be listed after a week, my lord.
After a week,
My lord.
Mr. Tara is here. You're taking his consent?
My lord, this is item number 8 is basically for impleadment, my lord. And item number 9 is the, my lord, the main petition, my lord, the
That's
retaping,
right. Is Mr. Tara here? No.
not.
Please show me that item. Just wait for some time.
Lordship.
Just wait for some time.
My lord.
Just wait for some time. Because this IA needs some orders. What is this IA for?
Impleadment, my lord.
Implement.
Some of the, my lord, some of the land owners, they claims to be the owners of the land.
So therefore, we can allow this application.
My lord.
Your Lordship. Your Lordship, my senior has instructed me to mention the item number 8, Your Lordship.
Oh,
He's out of town now, Your Lordship.
No, but what is the objection in impleading? Do you have any objection in impleading? Because the read petitioner is Mr. Kato.
My lord.
Your Lordship, I'm not aware about the facts of the matter. But
No, it's only an impleading application. You need not be aware of facts. Just wait for some time. Because this is an application, I think we should allow it. And then your petition will come after.
My lord, we don't have any objection, my lord, if they've been impleaded as one of the responsible. Much
So,
obliged.
this IA will be disposed of and then
My lord.
please remind me, I'll pass that order.
My lord,
Yes.
my lord, if lordship allows, my lord, a matter and we listed only to be withdrawn, my lord. Yes. Okay.
Yeah, Lordship. Lordship, I beg to mention item number 12, Lordship.
12.
I am for the respondent, Lordship, here.
Yes.
Lordship, we need some more time to check the instruction from our client. So let the matter may be this on next week, Lordship.
You're taking consent of the other side?
Lordship,
Okay. With consent of the other side, Mr.
J. Saro.
J.
Saro. S. J. Saro.
S. J. Sharu. Counsel for the respondent, private respondent.
Lordship.
Praise for adjournment, prayer is allowed. List after 2 weeks.
Much obliged.
Your lordship, I would like to mention item number 13, your lordship. The leading counsel is out of station for some medical issues, your lordship. The consent has been taken.
Okay. The grant that the council holding the brief is on medical leave. Mr.
N Roma.
N.
Roma, R-O-M.
Roma, R-O-M-A. Counsel for the appellant. Sorry, appellant it will be, huh? Appellant. Place for adjournment, prayer is allowed. List after 2 weeks.
Obliged.
My lord, may I mention item number 6, my lord?
Yes.
Oh, sorry, item number 4, my lord.
4.
Admission hearing, my lord. My
Yes.
lord, I am sorry, my lord, I haven't, my lord, my lord, come with the files and my lord, go through the records, my lord.
Just
This is for admission hearing, my lord. On next Monday, my lord, I'll item number 4, my lord. I'm for the respondent, my lord.
okay, you're taking consent?
Yes, my lord.
Yes.
MS Dangani.
Will it be listed on Monday, my lord?
Okay. Both sides are represented. They made by Mr. M. Kato, learned DSGI. Matter stands adjourned today. List on. Give it on Monday. Okay.
Deeply obliged.
Your Lordship, I beg to mention item number 8, Your Lordship. With the consent of other party, Your Lordship.
No. Let number 8 be called. Okay, just address this matter.
Be pleased, your lordship.
Just one. Please.
Yes, my lord, by filing this writ petition, I am praying before this court for partial modification of the Gazette notification dated 2nd November 2020.
Where is that?
That is page 20, page 29, page 29.
Page 29. Yes,
So here, this is newly inserted section 3A. So by inserting this section, all contractors, different contractors are clubbing together in a tender, inviting tender. So, my lord, kindly peruse page 30.
how are you affected by it?
Well,
How are you adversely affected by it?
I'm class 4 contractor and class 3 contractor. So as and when we participated in a tender process, then senior experienced contractors are clubbing together. That's why we are always deprived. Our tenders are always rejected, saying that you are class 2, you are class 4 like that. So last,
Can you show me any order where by which on the class you were ousted?
yeah,
Is there any order? Where just because there is another class, you were ousted on only on that ground?
yeah, in the
What is
last occasion, so this rejection order is not with me now.
No, that we can't entertain.
So,
When it comes before you,
Even-
then you challenge.
my lord,
When that order comes before you, then you challenge it. Now we are dismissing this writ petition. You don't have a cause of action. Right?
here in this instant petition, I have written some contractors who are rejected being they are class 2, and they are sometimes they rejected as a class 3 contractors because
No,
the
I understand.
financial bidding limits are
No, I'm
class.
You see, I'm not contesting what you are saying. You are absolutely right. There's no proof annexed in this writ petition. We will not go by hypothesis. Writ petitions are not to be adjudicated merely because you think so.
So due to this clubbing contractors together, many times at each and every tender opening and evaluation, it creates a problem, my lord, for all the contractors.
No, I know that. You see, when I drive my car in the left side of the road, I feel I get some problem. When I drive on the right side in a foreign country, I feel some problem. So, can be just because I am facing some problem, can the world change?
Yes, because amendment,
This is a small gate here.
yes, yes.
When you enter,
I understood, my
when
lord.
somebody is going
I
out,
understood.
you feel disturbed.
I understood.
So now, just because of that, can we change everything? In the flight, there are some people who are stout and they hardly fit in the chair. Correct? In a flight,
Yes,
when we sit in the chair, at times you find there are people who are healthy, they can't fit into the chair. So can we change everything? No, it's a decision of the government. No, I'm sorry, this is not
well,
entertained.
my lord. So I am the class 4 contractor. So I was many times rejected. That's why I have approached before this
No,
court.
it's okay. I'm not disbelieving you. But today, when I'm having this writ petition, those orders are not there. We can't entertain merely because it has been rejected. The rejection must reflect that the rejection was because there is a class 2 contractor and therefore you are found unfit. That is not the ground. In a competition, somebody may still get a preference.
By this amendment, they are just.
No, you see, I'll tell you, very simple. You see, you take a brand of pen. Any pen you are using, take a brand. The brand you have purchased is a very costly brand. Their pens start selling at 10,000 plus.
Yes, my lord.
Correct. Now you find it comfortable and you are using it. Now can a small time manufacturer come and say that, well, my pen of 10 rupees is not selling. People are purchasing 10,000 rupees pen. So therefore, please ban it.
No. That is, I understood, my lord, but especially in financial bid limit, both the contractors should not have been clubbing together. That's my.
No, that's a decision of the government. It
That's
is
why-
enlarging the scope. Sorry. Mr. U. Dekar, I'm counsel for the petitioner, and Mr. R.S. Nawab Bernard. Your Advocate General,
No, my lord, addition is still my lord.
additional Advocate General for the state. But I have not asked you. You are supporting the case of the petitioner?
I'm sorry, my lord.
You are supporting the case of the petitioner?
Absolutely not, my lord. They have not annexed the main document, my lord. The NIT. And as per NIT, it says my lord, contractor 2, whereas they are contractor 3 and 4. They are not at all entitled for that bidding capacity. my lord.
No,
Okay.
my
You say that-
residence certificate I have annexed.
You are
No,
registered
you
4 and 3.
you did not participate. In item number 1, you did not participate. Additional reason for the state. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the Gazette notification. Nine. Page 29, right?
Yes.
Page 29.
Notification dated 2/11/2020, published in the Arunachal Pradesh Gazette, dated 2/11/2020. By which the Arunachal Pradesh district-based entrepreneurs and professionals within bracket incentives, comma, development and promotional bracket closed. Again, one bracket amendment bracket closed Act, comma 2020 was notified. Page 29. The grievance of the petitioner is that he is a class 3 contractor and he is aggrieved by the said amending act by which the works department in the state are permitted to club 2 classes of tender. Sorry, the two classes of which they are permitted to enable contractors of 2 separate classes or more to submit their bids. Full stop. The learned counsel for the petitioners has submitted that there are several instances when the tenders, public bids submitted by the petitioners were rejected merely because a higher class of contractor had participated, and therefore the petitioners who were from class 3 category of contractors were ousted. Full stop. It is also projected that the petitioners had requested the respondent authorities to give separate financial bidding limit for class-wise contractors, but the same was not responded to, and the eligibility criteria prescribed in the said act was not modified. Hence, this writ petition. The learned additional advocate general has pointed out that in the writ petition, it is projected that the petitioner had not participated in the NIT dated 15/11/2023. Next paragraph. It is noted that there is a specific amendment made in the writ petition, as well as the synopsis appended to the writ petition, that the petitioners could not participate in some NIT process as class 3 contractors in the capital CD block of Damin, 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 Sangram, SANGRAM, Nyapin, NYAPIN, and Fasang, PHASSANG, in the Kurung, KURUNG, KUMEY district. And that the tender opening date was revised without proper corrigendum. Full stop. Next paragraph. On examination of the materials appended to the writ petition, it is seen that the petitioners have not annexed any rejection order of their bids on the ground that the other class of contractor was found more suitable, and therefore the petitioner, being a class 3 contractor, was rejected. Moreover, in the considered opinion of the court, if bidding is permitted to more than one class of contractors, it would give a broad participating base to the contractors. And in the process, contractor of a class who is of lower category is also permitted to bid in the submit his bid along with higher class of contractor, and therefore it appears that the policy of the government, which is notified in form of the Arunachal Pradesh district-based Entrepreneurs and Professionals So-and-so Act 2020, Amendment Act 2020, reflects the government policy of permitting more competition. in its in the bidding process. First one. Therefore, comma, this repetition is not supported by any rejection order of their bids merely because of the class difference. And as nothing contained in the Amendment Act of 2020 is found to be ultraviolence the Constitution of India, the court is not inclined to entertain this writ petition, and accordingly this writ petition stands dismissed at the motion stage without issuance of notice on the respondents.
Your lordship may kindly allow me to correct one thing, because 2 times your lordship have said, my lord, petition is contractor register number 3, my lord. He's a register contract number 4, my lord.
4.
4, my lord.
No.
5. 4, sorry, I'm sorry, 4.
No, you see this synopsis because I am.
My lord, they have annexed the register, my lord,
No,
27, my lord.
That's okay. But
Yeah.
you see, come to the synopsis.
Synopsis also says 4,
No,
my
no,
lord.
he said he could not participate in the NIT process as class 3 contractors.
Class 3
He's-
contract, that was
he's-
eligible for class 3 contractor, but
Oh,
his
he-
class
he's
is
4, class 4.
Yes, he is.
Make it class 4, not 3. Okay, okay. Because when I find this, I go by that. Okay,
Last 4.
Item number 2 also same, my lord.
same.
Same.
Here,
No,
here
in
the
item
petitioner
number
is
two,
class
there's a-
3.
There's a difference. There's some difference here. Item 2.
Here,
Class 3.
petitioner is the class 3. The registration certificate of contractor is annexed to it. And in this matter, my lord, the petitioner submitted tender, but he was not allowed. His tender was not received by the department. But so he is also challenging the same, clubbing the contractor together.
Where is it? How do you say that it was not received? Where is the tender?
Tender page 24, my lord.
I don't know. Please come to page 35. Come to page 35. Read the first paragraph. Recently, I participated in the tender. It was rejected. Where is the proof that you have not participated in a tender? It was not received.
This is by another contractor, my lord.
No, please, you see, Miss, Mr. Dekar, please understand that yesterday till 5 o'clock I was in the presiding in the court. So I was here in the courtroom, adjudicating matters till 5 o'clock. Then I took about 1 or 1.5 hours to correct all the orders and sign it.
Okay.
Then I go to my bungalow and read the brief. Correct. With the questions I'm asking, you must understand that I have read something.
Okay, my.
Correct. And then you say, when I'm pointing out from a document, from a paragraph in a document, then you say it is some other document. You see, I'm not in a movie where I'm looking at all those, where planfully I'm going there. Want to see that, what you call, dramatization. I'm taking a conscious decision of going to a movie and looking at dramatization.
Okay, my lord.
In
I
a
won't take-
repetition, can I
more
expect
time.
that from you?
Yes,
When I'm showing you from one paragraph, from one page, that means I've done some, I've spent some midnight oil. We had to change that. the petitioner, the grievance expressed by the Learned Counsel for the petitioner is that the authorities have not received the tender submitted by the petitioner. Post ex facie, the said submission appears to be incorrect and false, because in the synopsis, the petitioner has mentioned that he could not participate in some NIT process, and that the tender should have been opened on 29/11/2023, but without corrigendum, the date of opening was rescheduled. First off, it is not the case of the petitioner that he wanted to participate, and and before the closing date, the respondent authorities had refused to accept a tender. Then you add the things, and then you say, in the last you say, moreover, as incorrect statement has been made by the Learned Counsel for the petitioner at the bar, this petition also deserves to be dismissed on that count also. Stop. And of the matter.
Okay.
This is
Okay.
something I'll not appreciate.
All right.
Acha, just add Mr. Harish Navam, instructed by Mr. P. Pango, Government Advocate.
My lord, the connected IA was for stay of the judgment of the first
I
party
put
single.
one of
And
the
I am not
orders,
pressing the
no, in
IA.
one of the orders, I have found that there was an issue of maintainability made open. Maintainability was to be. heard.
Yes, yes.
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 You have raised the plea of maintainability.
I'm sorry, my lord.
You have raised the plea of maintainability.
Yes,
So you'll
but
have to address
already, my
first.
lord, already decided by this court. Similar matter has been decided. Item number 3, your lordship is taking.
Yes, and the last occasion lordship is,
Item
no.
number 3.
In the last order of 12/10/23,
Oh, yes.
it has been mentioned that Mr. D. Mazumdar, done as senior counsel, submits that the instant appeal is not maintainable in view of the settled position of law laid down in the judgment dated 4/1/2023, passed in WA 24 or 2023.
Hmm.
So therefore, if you have raised the plea of maintainability, you'll have to.
It has preferred an appeal. I have not seen that order. ma'am.
Yes, it is. 24 is the previous order of this court.
That's what I'm saying, right? That's why.
So
Previous order, I think I appeared in that case. There was an order passed by the division bench. That's why my learned friend, Mr. Mazumdar, has said that this is not maintainable on the ground.
no,
That there
because-
is already, now I have understood now what is, why he said.
Huh.
He said only on the ground that previously the matter has been decided by this court. Because there are similar matter where one of the matter there was a stay which was passed. So they showed that order and there was stay. Then your lordship decide that issue on this particular earlier case and that already have been decided. Now the whatever decision that has been passed, that is also be applicable in this case. So that is why he said that it is not maintainable. Where is the question of this?
So that's why you'll have to address me first.
Yes, yes.
Maintainability. Huh.
Now, my lord, will kindly see why
You
it
can
is
proceed
not
to hear.
maintained. About judgment. Yeah. Yes. Yes. Now, why it is not maintainable? Kindly see, my lord, the sketch first, the appeal which has been referred by them. Referred by them, what is the subject matter of this case and why it is not maintainable? Now, the order of the single bench, if your lordship will find, which they have put to challenge, is at page 91, kindly see mine. Relevant page at 91. Where the repetition judgment starts. 67 is the judgment. That is repetition 320 of 2021. Lordship, got it?
Yes.
320. And the judgment is 8/9/2022 at page 91. Page 91. Before your lordships, I place before your lordship the judgment. Kindly see the writ petition which they have filed at page 145. Before reading the judgment,
Yes.
145 is the writ petition. We have filed 320 of 2021. And it starts from 145. And the prayer portion,
147.
145,
Yes.
the writ petition.
Yes.
And the prayer of the writ petition is at page 140, 140, 190, 193, 192 it starts, 192, 192.
Yes.
Kindly see mal 193. A writ of certiorari shall not be issued for setting aside and questioning of the impugned order dated so and so board proceeding dated 8th of March 2021, second and third estimate bill prepared by respond number 3. A writ of mandamus shall not be issued to the respond number 4 to deposit the compensation as per the first land complaint estimate, which is yet to be deposited in the office of Deputy Commissioner for immediate disbursement of the compensation amount to be affected landowners and no appropriate writ or direction. So this is about, my lord, I'll just tell your lordship, the BRO has acquired this land. They are the acquiring authority. They acquired the land. Now in 2017, they decided to have a joint survey, and accordingly survey was done. And 2019, they decided in a joint survey that they are entitled to get a compensation amount of rupees 35 crores. They are entitled to get that amount. Now, this subsequently, what they decided to reduce the amount. They reduced the amount from that amount to a lower amount.
What is the quantum of compensation?
Yes, in this case, which I am just reading.
Yes, yes.
This is 35. No, in the present case. Which I am reading there. No.
Yes.
This or this is at page
No, just tell me the figure.
Yes, is 25. I'm just giving the figures to you. 25 crores, 35 crores, 35 crores, 94,01,935.
9401
935.
935.
Yes.
Yes.
And which was reduced to 25, 73, 97,
Just
937.
reduced to rupees 25,
73,
73,
97,
97,
937.
937.
Yes.
Yes.
Yes. Again, subsequently reduced to 1160.
Just a moment.
Yes.
11,
11, 60,
60,
60, 12, 680.
680.
Yes.
Yes.
Which was reduced. Now so this was put to challenge. This was put to challenge by us. And in the prayer,
the second reduction was put to challenge.
yes, both these 25 and 11 were put to challenge. We said we are entitled to get the first assessment of 35 crores.
Yes.
So this was a prayer which was made. And Lordship will kindly see the assessment which was made by them. First assessment which was made by them at page 206, which we are claiming. 206 of the writ appeal. This is 6th of March 2020. We are claiming on the basis of the first assessment. Then Lordship will find the figure at page 20678. Hmm. 35, 94, 94, 01, 90.
Just. Yes.
So we,
No, I am still in page 206.
206,
After that,
206 will be the estimate, final assessment,
yes.
which we said that we are entitled 35, not at the reduction price. And kindly see 6th of March 2020. Next page of 207.
Yes.
That is 35, 94, 01, 935.
Yes.
Lordship got it?
Yes.
This is what we prayed for. And according, that was the prayer. But my lord, they did not do anything. That is why we came to the court and filed a writ petition. And affidavit was exchanged, and ultimately a judgment was passed by this court at page 67. Kindly see 67. 67 is a judgment. It starts at 91.
Yes.
Now, if your lordship turn to page 91, 8/9/2022, kindly turn to page, next page is 92. Judgment is 8/9/2022. At page 92.
Yes. Yes.
Now at page 92, third paragraph.
Yes.
I'll just read the judgment, my lord. This is very small judgment. The petitioners who are 124 in numbers have joined together in filing the present writ petition. The petitioner affected by the acquisition of land for construction of a defense road from Changlam to so and so, which is to be carried out by 48 BRTF. It is a case of the petition that the acquisition proceedings were carried out whereby the petitioner was severed of their valuable land. Counsel for the petitioner submitted a joint survey and property assessment report. Both proceedings were conducted on 6/3/2020 and an amount of 35 crores 9401,935 so and so only was assessed as the estimated amount of compensation to the petitioner. Thereafter, a draft notification of land in question was issued under 41 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Reassessment Act 2013. However, the aforesaid notification is abandoned for the reason best known to the respondent authority. On the other hand, another notification in respect of the aforesaid land was issued by the Commissioner, Land Management, Government of Arunachal Pradesh on 10/3/2021 under section 10 of Balipara Tirap so and so. It is submitted after the compensation was assessed by joint verification. A notification dated 10/3/2021 was issued, and the response authority, more particularly the response number 3, has undertaken to exercise and to visit the estimated amount of compensation by refixing the rate of some of the items in the acquisition estimate, thereby reducing the assessed compensation amount to 25,73,97,937 by the impugned bill dated 14/8/2020. And thereafter, the amount was further reduced to 11,60,12,680 by the impugned bill dated 23/3/2021, which was prepared on the basis of both proceeding dated so and so, which was without any ground verification in most arbitrary manner. The learned counsel petitioner further sub in the case of the petition is squarely covered by orders dated 4/4/2020, 13/6/2020 in so and so respectively. This court by an order dated 4/4/2020 in writ petition 240 has already set aside order dated passed by Deputy Commissioner so and so. Now your lordship will kindly note down this 240 already decided has already set aside the order passed by so and so director, collector and arbitrator reduced the compensation amount to so and so, and the aforesaid dated was followed by an order dated 13/6/2020 in WPC 175 AP of 2022. The court also had the occasion to deal with the order dated 24/6/2021 by which the matter was referred back to for reassessment. This court, after hearing, while setting aside the order dated 24/6/2021, has remanded the matter back to Deputy Commissioner to make the disbursement at the earliest as per the entitlement of the petitioner without getting into the non-existing technicalities and merely making an issue out of it. For ready reference, the relevant observation of the aforesaid judgment dated 4/4/2022 is extracted herein below. The entire stand of Deputy Commissioner District is unacceptable inasmuch as the land of the petitioner has already been taken possession by the acquiring department. The acquiring department has deposited whatever amount is required to be deposited. There further cannot remain any issue with the Deputy Commissioner not to disburse the amount to the actual and owners by merely raising issues, one sending it down to the additional Deputy Commissioner for doing needful, and then again blaming the government for not making approval. If there is any requirement of law to act in such a manner, the same should be done at the earliest. A respondent by not doing the needful cannot make it to the basis not to make the payment. The entire act of Deputy Commissioner others appear to be arbitrary and unacceptable in law. Order dated 24/6/2021 is accordingly set aside. Learned counsel for the petitioner submit the acquiring authority, more particularly the respondent number 4 has not yet deposited the assessed amount of so and so. However, the land has already been acquired and 40% of construction road has already been completed by BRO so and so. Learned counsel petitioner submitted that in order dated so and so, this court has observed after hearing the parties and on perusal of material placed before this court is of the opinion issue being adjudicated and set to rest by order dated 4/4/2022 in the earlier writ petition being so and so. After hearing all the parties and the said order not being the subject matter of any further appeal, there is hardly any scope to take any other view, as the same would amount to sitting over the judgment of this court, which is not legally permissible. Apart from the same, in the order dated 4/4/2022, which was passed after hearing parties, elaborate discussion were done and determination of rate has to be understood only for that part, wherein the same was not fixed. Further, it has been categorically observed, if the landowners are ascertained and the amount of compensation is to be paid is determined, there cannot remain any further issue for the government not to give the approval of the government, cannot hold back the grant of approval without any valid and acceptable reason. This court also finds force in the argument made on behalf of the petitioner that the same authority is in order dated 9/5/2022 by referring to the earlier order dated 4/4/2022 passed in so and so, has clearly observed that there is no scope for any re-verification or reassessment except for verification to include the left out parties, and the same would amount to serious violation of the order of this court. In view of the above, the impugned bill dated 14/8/2020 of so and so, and the impugned estimate bill of 11 crores dated, which was prepared on the basis of board proceeding, dated sent set aside. Accordingly, director, the acquiring authority, more particular respondent 4, shall deposit the assessed amount of 35 crores so and so only in the account of deputy commissioner within a period of 1 month from date of passing of this order. So and so shall disburse the same, each of the beneficiaries within a period of 15 days after. So this was put to, now the government has come and challenged this order. Now, earlier to that, already there is same subject. Changes is different. Already this court has decided. It was passed by the same the honorable single judge, and it is decided by division bench. Only changes is different. Rest occurring by BRO. The amount also is different. Now I will show that. That order, kindly see my board order, your lordship decide. 24. That is why there is the Mazumdar has said this is not maintainable. Already decided by this court. Para, my lord, 1 second before going to that, my lord will kindly see writ appeal, para, page 60, kindly see. Page 60, para 14, kindly see. Page 60, para 14. See para 14. That being aggrieved, para, yes,
Page 60.
para 14. Now see para 14, that being agreed by the judgment order dated 13/6/2022 in WPC number 175/2021, so and so, the state person preferred writ appeal, being writ appeal number 24 before the division bench of this court, and the honorable court wide order dated 27/10/2022 has stated the operation of the impugned judgment order dated 13/6/2022. It is imperative to mention here that the issues involved in writ appeal number 24 of 2022 and the present writ appeal is similar and identical. As such, the honorable court may please to pass similar order. So what has happened when this writ appeal was moved before this court? There was a writ appeal prior to that, and there was an interim order which was passed by the court. So they said it is similar, so similar order should be passed. Accordingly, similar order was passed by this court. But by the time this court has decided that case, now your lordship will kindly see, this decided on 4/1/2023. Subsequently of filing of this writ appeal. See the date, my lord. 4/1/2023. Lordship, see the date. 'Writ appeal has been filed 12 December 2022, my lord. Lordship will kindly note down this writ appeal, which was filed by the government, was on 24 to 12 December 22. 12th of December 2022. And the judgment which was passed, similar, they said, which I have placed it, 4th of January 2023. This judgment passed. Now kindly see the order. That is why my learned friend Mazumdar said that it is not, because already decided the same subject. Kindly see, man. Because they took a stay order on the basis of that order. Now that has been decided by this court. Kindly see, my lord. Same. Only the stretch of that land is different. The BRO is the acquiring authority. Same.
Petition 175.
Yes.
You have also referred to writ petition 240.
Yes, right. Everything is referred. So now, what is, my lord will kindly see.
Yes, this is, we remember that, this judgment.
I'm sorry.
No, this is, I'm remembering it.
Right. That's why my learned friend Mr. Mazumdar said that where is a question now that writ petition, writ appeal goes.
Just for the benefit of my brother, please say the operative part of this.
Yes, I'll just say the operative portion of the order. My reasons and decision, my lord, will kindly take to that. I'll just read that. Page number 16. Page number 16. Well, I will just read the operative portion, paragraph 11, that page 16.
Yes.
It is noted that this court by judgment order dated 4/4/2022 in writ petition 240 of 2022 had taken notice of the notification dated 26/11/2011, whereby the government of Arunachal fixed the rate of compensation of several items enumerated therein. However, as the compensation was already determined and the central government has deposited the compensation amount of 27 crores 81,59193 as SS, learned single judge set aside the order dated 24/6/2021 issued by Deputy Commissioner so and so as unacceptable and directed Deputy Commissioner either to pay compensation or to return the land to the landowners. However, it was observed that if the rate of any of the item in the acquisition required to be determined, additional Deputy Commissioner so and so was permitted to do it within 15 days and place the matter before the government for his approval. And it was provided government cannot hold back grant of approval without any valid reason. Direction was also issued to bring the matter to its logical conclusion within 1 month. Admittedly, till passing of the judgment and order dated 13/6/2022 in WPC 175 of 2022, neither the state of Arunachal Pradesh nor the Union of India has preferred any appeal against the judgment order dated 4/4/2022 in writ petition 240 AP of 2022. However, the authority has conducted a fresh assessment and issued the communication dated 1/5/2022, which has been impugned in WPC 175 of 2022. Therefore, as no appeal has been preferred against the said order dated 4/4/2022, passed in writ petition 240 of 2022, learned single judge rightly passed the judgment and order dated 13/6/2022, passed in WPC 175 of 2022, which is impugned in the present appeal. Moreover, the learned single judge also directed disbursement of compensation to be paid within 45 days. Till the date of hearing of this interlocutory application, the position remains the same. That is, no appeal was filed by either the state of the Arunachal Pradesh or by Union of India against the judgment order dated 4/4/2022, passed by the learned single judge in WPC 240 of 2022, wherein the learned single judge taken note of the notification dated 26/11/2011, by which rates of certain items were fixed for the purpose of determining the land acquisition compensation. Therefore, in the considered opinion of this court, this appeal deserves to be dismissed on the said ground alone. According, this court is inclined to pass the following orders. In the light of discussion so and so, before parting with the records for end of justice, we are inclined to provide further 30 days time from today, that is 1/2/2023, to the appellant joint and civil disburse the land acquisition company to the respondent. So that is why my learned friend is saying that this is not maintainable, already been decided by this court, because they relied this order, this particular case, on the basis of the earlier case. Your Lordship, that's a paragraph 14. So this is absolutely not maintainable in this part. Nothing remains.
In this preliminary point, what do you have to say?
No, Lordship. In fact, Lordship, the situation has changed, Lordship. While filing this writ appeal, Lordship, the situation was something else, because that writ appeal was pending and interim order was passed. Now, suspending the order passed by the single judge. Now, since the writ appeal has been dismissed, and I fairly have to admit, Lordship, the stage is same, only the change is different. Now, in fact, in the writ appeal, we have raised the issue that while passing the judgment and order, in writ petition 240, this honorable court has afforded a scope for the state to redetermine the compensation in its judgment in FERA 6. So while exercising, as the state government were given the liberty to reassess some of the items, rate of the some of the items. So we did that. Lordship may kindly come to page number 109. No, sorry, 108, Lordship. So in fact, this writ appeal is connected with the writ appeal, which has already been disposed of by this honorable court. Lordship may kindly turn to page number 108 for once, Lordship.
108.
Yes, Lordship. This is the Lordship judgment on order passed on 4/4/2022 in WPC 240. In fact, this WPC was filed by one Manaksa Tapla. In fact, the issue was similar, and while disposing this writ petition in para 6 of the judgment, Lordship.
6.
Yes, page number 108, para 6. I will just read this para, Lordship. If the rate of any of the item in the acquisition required to be determined, let the additional deputy commissioner Anjao do it and complete the same within 15 days from the receipt of the certificate copy, and thereafter the matter be placed before the government for its approval. If the landowners are ascertained and the amount of the compensation to be paid is determined, there cannot remain any further issue for the government not to give the approval, and the government cannot hold back the grant of approval without any valid acceptable reason. So, Lordship, the state government has notified the rates of each and every plants. Although this cardamom were now confined to cardamom now. So in that notification, the rate of the cardamom was not prescribed. So,
No, I even remember the question which we had asked on that earlier occasion
Lordship,
when we were hearing writ appeal 24.
yes,
The question was that after having read that brief, I went to the market here in Itanagar. This market I had gone. I visited it, but I did not find any cardamom grown in the state of Arunachal Pradesh being marketed or sold in this Itanagar or Naharlagun. I really wanted to see if that much amount of cardamom can be grown in the side of the road. If in the side of the road such a valuable trees are there, definitely in the interior there would be 10 times more. So I went to the market, I did not find it.
it is in fact, Lordship, grown in those areas.
No, I don't know. You see, if there is a production, there must be a sale.
Yes, sir.
And where would we sell it? There must be some pocket where it can be sold. And cardamom is something I keep in my pocket. So I just wanted to have the Arunachal cardamom and did not find it. Maybe I went to the wrong place. But it's apparently not available in the market area where in the near the bungalow. There's a market up to the bridge I had walked. But this Arunachal cardamom nobody could identify and sell it to me. Now this page 108,
Yes,
paragraph
sir.
6.
Para 6, Lordship.
Yes. Now how they have done it? Can you show us? How was this rates revisited?
Yes, Lordship. Lordship. So after the this judgment and order was passed, Lordship. Of course, the land acquiring body did not reassess, but it has only this reassess the rate of the cardamom. And then rate of the cardamom, it was in fact assessed and it was fixed by the order dated 8/3/2021. That is at page number 142.
140.
Yes, 142, Lordship.
But this will not be expressly admissible. It cannot be expressly admissible. Page 141, right?
142, Lordship.
140,
142, Lordship.
142. Same thing. It's a part of 141.
Yes, this is a
Both
part of what,
proceedings.
yes, Lordship.
It is expressly not admissible. You see why? I'll give you the reasons. Come to page 126. Come to page 126. 126.
126.
Yes. One to six is the board joint survey of 6/3/2020.
Yes, Lordship.
Your rate fixation of cardamom is on 8/3/2021. So subsequent rate cannot become the ground for reassessment. The assessment must be done on the basis of the rate fixed there at the time of taking.
Lordship, we have a notification of 2011.
I agree, but you tell me a situation. Yesterday morning, when I came to for the first time in this such a long gap, I gave to my staff 50 rupees to purchase 1 kg of potato. Correct. So he got some potato of 50 rupees yesterday morning. Now, incidentally, today we are coming just in front of this junction. I got down and asked the rate of potato today. He said this is 40 rupees. Yesterday it was 50, today it is 40 rupees. So this 10 rupees, from whom should I get the refund? I asked the Congo given to refund me 10 rupees. Or I go to the potato seller near Nahavan and ask him to refund 40 rupees because today's rate is 40 rupees. But I took and consumed potatoes yesterday. I'm very concerned because 50 rupees I think no.
That depends on Lordship, demand and supply, in fact.
No, it's not a question of demand and supply. You see, if the rates are fixed on the basis of subsequent assessment, then I am entitled to 10 rupees refund. I'm giving a good example. Examples are always horrible. Okay, my immediate response is okay, what I can think. Because I spent from my pocket, 50 rupees. Today it is 40 rupees. So before the company, we are able to accept your argument.
Lordship,
Then
I leave it to Lordship.
So, yeah, that's just because we. Always suffer for it. Okay, this is, okay.
Lordship,
What is the favorite?
Lordship.
Yes. No, no problem.
It was, this was for stay of the operation of this.
Stay. Stay.
Much
Simply
obliged.
obliged.
Lordship, in this case, steps steps upon respondent number 2 is completed. 3 is awaited. Record it was called for, and it seems record has come already. So we have to.
Yes, Your Lordship, but then the office note states that with regard to the service on respondent number 2, the address given is insufficient and therefore it was written.
Three. Respondent number 3.
Oh, respondent number 3, Your Lordship. Both of respondent number 2 and 3 were the victims. Your Lordship. Yes, Your
2 victims. Or else, Lordship, amicus can be appointed for them.
Not served.
2 is served. 3 not served, Lordship. Lordship.
fresh step, Your Lordship. No, no, Your Lordship. Your Lordship, I passed that order, Your Lordship. Yes, Your Lordship. Deepak Nayak, your lordship.
Otherwise, your lordship, in other cases also I'm appearing as a project successor. Thank you.
Yes.
Teaching, teaching.
Yes.
Highly obliged.
Yes, I've got the question.
Your lordship, may I plead? This is criminal appeal against the conviction order dated 22/9/2023. Yes, it's coming for first time. So, one is IA. Sentence is 20 years. He has been convicted in 3 count. This your lordship may see page 126. 126. 126. Yes, ma'am. 126. And 103. Yes, 103. Convict Thomas Lemnick is sentenced for 20 years, rigorous imprisonment and payment of fine of rupees 20,000 for the offense of aggravated penetrative sexual assault, punishable under Section 6 of the POCSO Act, which is minimum punishment for the said offense. Convict Thomas Lemnick is sentenced for 7 years imprisonment and payment of a fine of 5,000 for the offense of kidnapping of the minor victim under Section 363 IPC. Further, Thomas Lemnick is sentenced for 5 years.
Just officiating a head of promotion, which was done on 9/5/2026 and 6/6/2026, 6/6/2006.
Just a moment. Please come again.
My lord, we have filed this leave application, my lord, since we are not arrayed as a party in the writ petition, my lord.
You are not a party. Okay.
We are not in the party, though we are adversely affected by this order, my lord. I'll say why, my lord. I'll submit why. Therefore, we filed this leave petition, my lord, seeking leave of your lordships to file an writ appeal against this judgment and order of the Honorable Single Judgment. Then order of the landed single was passed on 5/7/2023 in WPC number 297 AP of 2023, and thereby, my lord, granting my lord the retrospective regulation promotion of the respondent number 345 hearing with the date of their ad hoc promotion, which was done in 6/6/2006 and 9/5/2006. My the DPC was held. DPC gave their promotion with the date of from the date of their DPC. My lord. The DPC was held on, my lord, 7/9/2020, and the DPC has granted their promotion with the date of their regularized their promotion from the date of their DPC 7/9/2020. Against that, SL this in the said WPC, and the Honorable single judge has interfered with that, and my lord, they are given with retrospective regulation promotion from the date of 2026. My lord, we are all regularly direct recruiting in the post of assistant engineer. My lord.
The DPC recommended from when?
From my lord, date of the DPC 7/9/2020. That, my lord, will find at page 1208. My lord. Subsequent to DPC's decision, an order was issued. My lord. 208 of the my lord leave petition.
Yes, Mr. Saikia. Mr. Luan, please.
I have for the matter, leave petitioner and we have the respondent matter. I have objection, my lord, to the matter leave application filed by the matter, the applicant's matter, appellant's matter. My lord, they
Then-
have.
No, if you're objecting to it, we will reject that, but we'll say that this order of DPC of the promotion will not affect their career.
Oh, obviously, my lord. My lord, what I say, my lord,
No,
they-
it's not that. It's very simple. You're objecting to leave application.
my lord.
That means the petitioner, you don't want the appellant to be affected by this order of this court.
My lord.
So we'll permit that. Correct. So he'll not be affected by this order. So his case will not be in prejudice to the case of the respondents. We know that.
Because, my lord,
No question of because. It's
Yeah.
a simple thing. If you don't want Mr. Ghosh to be affected by this order. That's why you are objecting.
Yeah.
So if you are objecting, we'll release Mr. Ghosh. As simple as that.
My lord,
Sit down, take a decision, speak to your friend in the for the government, and then take a decision. If you're objecting to the leave application, that means you don't want him to be affected. That's a presumption. Because nobody can be condemned unheard. That is
because
the
my lord,
principle.
what I'm submitting is that, my lord.
No, no question of because. Because means that you have to say something.
Yes, my lord.
I'm not on that. Leave application is not more than 2 minutes.
The question is whether he was supposed to be heard at the time of my lord.
No, definitely he is not heard.
Yeah.
One cannot be prejudicially affected if he is not heard. So why we take more than 1 minute to
Because
2 minutes time here?
He was, my lord, in their knowledge, the writ petition is pending before this honorable court, my lord.
Oh, I have knowledge. You see, US president election is coming. I have knowledge. I have knowledge that there is a war in Ukraine going on. What does this knowledge have mean to me if I am not given a notice to be heard?
Or my lord, may leave application may be allowed, my lord.
And this is one. Second is
Second
why against the recommendation of DPC, promotion, ad hoc promotion should be counted as an the retrospective effect can be given to that promotion. That is the interim IFO. Now you address us on that.
I will, my lord. My lord, basically, my lord, the petitioners were, my lord, the writ petitioner, my lord, here the respondents, my lord, were, my lord, promoted to the post of my lord, on officiating basis in the year 2016, 6, my lord, against the clear vacancies, my lord. This was also findings of the DPC also, my lord. That we were promoted on officiating basis with pay scales, my lord, in terms of the rule, my lord, in 2006, my lord, and thereafter, my lord, no DPC has taken place, my lord. And subsequently in 2020, my lord, DPC was held, my lord, and by that DPC, my lord, our promotion was, it was, my lord, for the purpose of regularization, my lord, of all the officiating estimates, my lord. And DPC, my lord, after finding everything, my lord, the rule, in terms of the rules, we were eligible at the time of, my lord, the officiating promotion, and we have complied all the, my lord, requisite, my lord, requirements of the recruitment rule, my lord.
Any judgment of this court or Supreme Court which says that retrospective promotion can be given from the date of officiating promotion?
Yes, my lord, that has been considered in the judgment, my lord.
Which is the judgment? Show that judgment.
I will show the judgment, my lord. Lordship, kindly. Judgment, Lordship, will find at page 322, my lord.
Mr. Ghosh, where is that seniority, interstate seniority list?
My lord,
Seniority list will be fine, my lord. At page, my lord, 81, my lord.
81 of the writ appeal?
Writ appeal, my lord. No, my lord, this leave application itself, my lord.
Leave application. Leave application is this IA 156.
Yes, my lord. Leave application, my lord, 156, my lord.
156. Yes. What is your name?
My lord, my name is, my lord, Moli Tatu onwards, my lord.
May I interrupt, Lordship? May I say, my lord, if your Lordship look into page 24-hour, my lord, the leave petition, my lord, I have, my lord, summarized the position of the seniority list made after the DPC on 7/9/2020. That, my lord, will find it page 24, my lord.
24.
Yes, I have summarized the seniority position of the gradation list of, my lord, 14/12/2022 between us and between we applicant and the, my lord, the respondents 3, 4, and 5. Page 24 and 25.
Okay.
I summarized.
So this, the applicant
is the position,
applicant is at serial number 37.
No, my lord. Applicant is Moli Tatu. He is page 51, my lord. 37 is us, my lord. We are the applicants. 1 to 14
That's
are
what,
we.
that's why I'm saying, I'm considering you as an applicant now.
My lord, we are
Ah,
serial number 37 to 50. In the
37
gradation,
to 50.
In the
Okay,
graduation list of 14/12/2022.
yes.
And their position, my lord, next page, Lord, you will find at page 25. They are from 51, Molita to Jombalwa and Itum Naso. They are the three respondents here, and they are 51, 52, and 53.
51, 52, 53.
Lordship. Now, if the retrospective given with the retrospective offer, actually the seniority list, they will be senior over to us. That is their case also before the honorable singular. That is their relief claim in the
Mr.
writ petition
Segia,
also.
anything to controvert this? Anything to controvert this?
There is a mention in the seniority list there, and our seniority will be subject to outcome of the writ petition, madam.
No, that is okay. Here, Mr. Ghosh is pointing out that your position in the gradation list is 51, 52, 53.
That
you
is
dispute that?
after the DPC, my lord. After the DPC, my lord.
I don't get it. I don't get it. I'll give you an example. My examples are always horrible. More horrible than the earlier one. Now you see, these are my two court officers here. Mr. Saikia, I have these two court officers here. One the bench, the court master, and one is my secretary. Correct. They have different positions in the seniority list. He may be at serial number 1, she may be at serial number 2. Correct. After DPC, can I, if I accept your submission, can I say that after DPC, her position will be number 1 and his position will be number 2?
No, madam.
No.
Subject to, my lord.
No, that's what I'm asking you. I said that, are you disputing your position at 51, 52, and 53?
Yes,
You said that yes, after DPC. So after
the,
DPC, your serial number has changed.
After the judgment, my lord, we are disputing, my lord, that seniority, my lord.
After which judgment?
After the judgment rendered in the.
Oh, no, that's why we are staying it. That has to be stayed. Your seniority position can't change.
Well, there is specific mention in the matter seniority list, my lord, that the seniority position will be, my lord,
Altered.
Altered, my lord, after the judgment.
On what basis?
My lord?
On
On
what
the basis of the judgment, my lord.
No, that's why we are staying it. Your seniority position can't change.
My lord, this was, my lord, rendered after the DPC, my lord, and my lord, on the basis of the DPC, my lord, seniority, for the first time seniority list was prepared, my lord.
No. My lord, there are
How
other
will the position change? How will the seniority position change?
It is changed, my lord, on the basis of the, my lord, judgment, my lord.
That's
It
why we
will
are
be
staying
changed,
it.
my lord.
That's why we are saying it. We will have to examine it. It has to be examined. This can't prevail.
একটা পেজ নাই
My lord, may I pray that, my lord? My lord, may allow the leave application, my lord, and there is a condemnation application also, my lord. My lord, in that condemnation application, we will file objection on us. And my lord may take up this matter on the admission hearing, my lord, on the next day, my lord. My
No,
lord
there's
has granted the leave, my lord. And now, my lord, the
My lord,
condemnation has to be heard, my lord.
as soon as my lord, we came to know the judgment, we filed this writ petition. We know it from the Department of 25A. I have, my lord, mentioned it in paragraph 14 and 15 of my IA, my lord, page 11. There's only a 40 days delay, my lord.
I'll have to issue a notice. It may be a short notice, but I'll have to issue that.
My lord, that's I leave it.
Mr. B.J. Ghosh, learned counsel for the applicants. And yes, you have something to say?
No, madam.
This continuation petition is Lordship 154 of 2023, IS Civil.
No, it's okay. I was the leave petition.
Leave petition Lordship numbered is 156 of 2000.
Yes. Mr. Ratan, I'm sorry. I'm really good growing old. Mr. And Ratan Tanan. You're appearing as?
Additional AG.
Additional Advocate General of the state. Representing respondent numbers, opposite party number
1 and 2.
1 and 2. And Mr. R. Saikyal under counsel for the opposite party number 3, 4, and 5. Next one. By this will be in 156, leave application. By filing this leave application, the applicants who claim to be adversely affected by the judgment and order dated 5/7/2023 passed by the single judge of this court in WPC 297 AP of 2023, are praying for leave to file the connected appeal. Full stop. The opposite parties number 3, 4, and 5 have filed their objection in form of an affidavit. Next para. Very simple. The same has been considered. After hearing the learned counsel for the said opposite parties number 3, 4, and 5. Next paragraph. The court is of the considered opinion that even if the applicant alleges semblance of being adversely affected by the impugn order. Comma. They would have a right to be heard. Because of the well-settled legal position that one cannot be condemned unheard. Full stop. Whether or not there is a merit in the claim is to be decided in the connected appeal and not while deciding the leave application. Full stop. Next paragraph. Therefore, despite objection made by the learned counsel for respondent numbers, opposite parties number 3, 4, and 5, this leave application stands allowed. Just to enable the applicant to ventilate their grievance of as to how they are adversely affected by the impugned judgment. By the judgment impugned in the connected appeal. Full stop. Then this IA 70.
IA 154 of
There's
23.
there's a caveat.
Okay, great.
74. The caveat shall be heard. Which stands in the connected appeal, who stands discharged. The caveat will be Mr. R. Saikia. And then IA 154. See, there was a DJ Ghosh for the applicant and also for the opposite parties. By filing this application under Section 5 of the Limitation Act, the applicant has paid for continuing the delay of 40 days beyond the period of limitation in filing the connected appeal. The learned counsel for the opposite parties number 3, 4, and 5 has prayed for time to file their affidavit in opposition. The case of the applicants is that they were not parties in WPC 297 AP of 2021, and therefore the judgment impugned in the connected appeal was not filed, was not passed in their presence. So therefore, the court is of the considered opinion that the projection made by the petitioner, the applicants, that the information of the impugned judgment and order dated 5/7/2023 came to knowledge of the applicants on 25/8/2023 from the concerned department. Full stop. If that be so, this interlocutory application for conversion of delay filed on 15/9/2023 appears to be on time. Expert ex officio appears to be on time. Nonetheless, you should notice returnable in on give a date before vacation. Two 2023. Affidavit in opposition, if any, by filed by at least 1 day prior to the next date of listing. List on 20/12/2023.
My lord, just I have a small prayer, lordship.
Yes.
My lord, since my lord, the government responded, my lord, may not be not to proceed with the judgment, my lord. Otherwise, my lord, appeal may become infectious. Though, my lord, a notice has been issued, lordship, on the limitation.
No, we can always turn the clock back. If we find that you are affected, the writ appellate court will not be powerless to turn the clock back.
That I understood. That I understood. Understood. Obliged, Lordship. Deeply obliged.
Just make that observation in the order. Just make that observation in the order. Before issuing notice, right, the learned counsel for the applicant also expresses apprehension that if the government implements the impugn order, the applicants may be prejudicially affected. Full stop. In this regard, the court is of the considered opinion that if the appeal is taken up on board, the court would not be powerless to provide appropriate relief to the applicants, and therefore the learned counsel for the applicant is at liberty to renew the prayer at an appropriate stage. Let me say this. So I've given you that liberty. You raise this issue in the appropriate stage.
Lordship, deeply obliged. Deeply obliged.
That order may be effect while hearing the final appeal, my lord. Because, my lord,
No.
they have not put to challenge the findings of the DPC, my lord. And we have also not challenged the findings of the DPC, my lord. No one has challenged the findings of the DPC.
This observation not, you will have a right to prefer an appeal. But this observation will not affect them. He has made a prayer, I have rejected it. How will that observation affect? You tell me, I'm full ears. I am hearing you. You tell me if a prayer is made and I am rejecting it, how will it affect you?
My lord, it may affect while hearing the final appeal, my lord. This is my submission.
No, you see, there are two things besides Saikia. Number one, I have almost passed an order in the condonation application to allow that. Correct? I have given the reasons. Now, if on that ground I allow the condonation application, even without hearing you can't say that you are suffering any prejudice because of the fact that the affected party has not been heard. That is number one. Second is, in stricto sensu, the petition of the court to pass an order, despite condonation application being filed, is no longer res judicata.
Yes.
There is a judgment authored by Honorable Justice J.N. Sharma, as he was then, where despite the notice being issued on a condonation application,
Yes.
the execution proceeding was stayed. I'll just, if you want that,
Yes.
if you want that, we'll give you right now.
I have gone through the judgment.
You have the judgment.
I don't. Right now, I don't have ballot bike. I have gone through my life. I forgot now. This is J.M. Sharma. Then another judgment passed by Justice Chaudhary also.
There is something I have been using it constantly.
My lord.
It's just because I am growing old, I don't remember it. I don't remember the citation. I remember the judgment. I don't remember the citation.
Yes.
I'll give it to you. So I can, not I, for plural. We still have the power to pass an interim order despite issuance of noticing the condemnation application. I'll just give you that citation.
Yes.
I am not disputing that aspect.
No. It's not that. But I'm saying so. But when you say that you are prejudiced, I can civilly prejudice you by passing an order of stay. Not I means we. Correct. It's just a bad habit of saying we. We still have the power and authority, backed by the decision of this court, to interfere with the impugn order, despite issuance of notice on the respondent. I'll just give that citation. That is why when I fail in the writ petition, I go back to my alma mater, CPC. Yes. The case is Ramesh Chandra Kalita versus Meera Patwari. Reported in 1997, 1 GLR 287. It's a very short order. And this is how Honorable Justice Sharma has dealt with the matter. A fair interpretation of Order 41 Rule 3A of the CPC would be that it requires appellant to present an appeal after expiry of the period of limitation. It shall be accompanied by an application supported by affidavit stating reasons of delay, so and so, so and so. After all, 41 Rule 3 is a procedural law, and this procedural law must be interpreted in such a manner so that to advance the cause of justice. If the power to grant this stay is not given in exceptional cases, this will cause sheer injustice to an appellant who may be prevented from filing an appeal on time because of compelling circumstances. After all, law cannot be allowed to be utilized to cause injustice. In such a situation, the court can exercise power under Section 151 CPC to grant relief in such a case if the justice demands it. That is the mandate of law and is the requirement of law. Accordingly, this revision application stands allowed, and the stay application shall be considered by the lower appellate court in accordance with law. So this Order 41 Rule 3 is 3A is that condemnation of delay in CPC. You don't need to file Order 5 application under Section 5 in a civil appeal under Order 41. So therefore, this is the judgment of this court, and I am thoroughly acquainted with this. I have not even used it. I have also followed this. So therefore, procedural law is something we can also always overcome. Correct. So the question of your prejudice is non-est. Either you take this on innocuous observation of this court, or I'll be compelled to stay it ultimately.
For next
your
occasions,
choice.
my lord, this provision will apply to me, my lord.
Pardon me?
Next occasions, my lord. Highly appreciate.
Okay. Take a break. We'll come back.
Lordship, this IA is for impleadment, Lordship.
Impleadment.
IA 162, Lordship.
Yes. So why you require to be impleaded?
Lordship, I'm aggrieved actually, Lordship, by the action of the administration, Lordship, in the whole acquisition process, Lordship. I've been kept in dark, Lordship. The section 11 of Lara Act was not complied with, Lordship. One of the respondent in the read appeal, Lordship, who is claiming to be the owner of the Malini area, Lordship.
No. You can't be impleaded in this appeal because of the fact that this appeal is in respect of the order passed in the writ petition. Were you parties in the writ petition?
No, Lordship, I didn't.
No. Then you will have independent right. In the Union of India's appeal, you can't become a party. You see, if they have not complied, you'll have to reiterate, agitate your own case by filing a writ petition. In their appeal, you can't become a party. Same principle applies. You see, you are not a party, and therefore you will not be affected by the appellate order.
Lordship,
You
the,
see, I'll give you a simple example. Last example I gave, again, one of the horrible examples. The courtmaster here is seniority number 1, he's seniority number 2. There is another person, he is seniority number 3. Correct?
Lordship,
These two have come to court claiming what you call promotion to 2 vacancies which are available. And the writ court allows it. Correct? The government comes in appeal saying that these 2 posts cannot be given to them. Now in appeal, can third party join and then say that no, this judgment, please don't interfere with the judgment, or I have my own right. If they have their own right, the third person will have to come to court in his own, on his own strength or weaknesses.
Lordship, the contention which has been raised by the Union of India is the same contention that I'm raising in this instant case, Lordship.
But you can't still object. You see, whatever is the contention,
Lordship.
if you have to, if you are not the writ petitioner and they got a relief, that is the relief which the Union of India is assailing. The court could not have granted it. That is what he is saying. Now, how can a third party come and interfere?
Lordship, here,
Because you can't be a party when you are not there in the writ petition. You can, at best, what you can understand is that you can be an intervener. But intervener will not have no right to file their affidavit and make a contention. You can only just watch the proceedings and assist the court if required, if called for. You can only be an intervener if you think you are affected. But you can't become a party, getting an independent right to file an affidavit in opposition in the matter. You are aware of the limited rights given to an intervener.
Lordship.
The intervener can only be there in the court and watch the proceedings. You don't have a right to file a pleadings on record.
Lordship.
So it's your choice. If you say that you want to be there as intervener, that is okay. But if you want to be a party, then this prayer has to be rejected.
Lordship, otherwise I may be allowed as intervener. Lordship.
You take a call, take a 10 minutes time, you discuss with someone if you want.
Lordship.
You'll take it after some time.
Lordship.
Take a decision.
Lordship.
Yes, what do you have to say?
This is the whole contention matter, the specifically raised by the matter, the now present second matter. No procedure has followed the accusation process.
No, I'm not on that. I'm only the principle of the applicant being inducted as a party to the appeal. What is your contention on that?
If they wanted to implement in the manner, the ATC state manner, the reporting manner, it was pending for such a long period. They haven't been there. Now ATC state manner, they cannot be one of the respondent in.
And when you take a decision, you also think over on one point. Number one, this is the only point, not number one. This is the only point. The point is that once you participate in these appellate proceedings, the applicants will be bound by the order which is being passed by in the writ appeal. Then you can't re-agitate that point again. Please take that call also.
Lordship, we have filed our objections, Lordship,
No,
regarding.
objection is something else,
Lordship.
but we are not adjudicating it right now. I am asking him to take a what you call that word is informed decision. Correct.
All right.
Both when you are intervener or you are a party, you will be bound by this order. Today you are not bound by that order.
Correct.
You are just getting a benefit of the writ appellate order. But if the writ appeal goes against you, you still have right to agitate. Please take a informed decision. Correct?
All right.
Okay.
All right.
After some time, let him take a call. Let him think over. If you want, we can adjourn the matter also.
Yeah. Lordship, after 10 minutes, Lordship.
Huh?
I'll
After
take
10
this.
minutes. Okay.
Yes. Lordship, in fact, some instruction was sought from the PP yesterday.
Oh, yes. Yes. Yesterday's matter.
Yes, ma'am.
This yesterday's matter.
Yes, ma'am.
Yes, your lordship. Here is the judgment of our division bench, our High Court division bench, whereby it is observed.
It's okay. Give it one. We'll.
In para 6, next page. May I read this? It's only single line para. From this para, it also seems that Supreme Court has also observed a similar. Examination of magistrate may not always be required, except in the absence of any circumstances justifying calling of the magistrate as witness.
No, but the next word is that the accused simply stated that he was brandishing so and so. Therefore, it's not a confession. So the Supreme Court did not treat it. Our High Court did not treat it as a
Yes,
confession.
here in this case, accused was brandishing, and on the ground of self-defense, his conviction was converted.
You see,
This-
yesterday I did some research. Not even in a single case we found that the confessional statement was not even exhibited, not even marked. In this case, only the document is marked. The content is not proved. The signature of the magistrate is also not proved.
Yes.
It can't be a recording of confession.
For proving, magistrate has to appear in person.
No.
He has to exhibit his signatures.
If for some reason he is not called for, then there will be something in the order sheet saying that his personal appearance is dispensed with. Number one. Second is that the IO, we can accept that the IO has exhibited that document. But what is the standard of proof? Marking of a document is not a standard of proof of the document. The exhibiting of the relevant part would be a standard of proof for a document to be for an entry in the document to become admissible.
Your Lordship, I have another rulings. It was delivered by the Division Bench of Madras, presided by Chief Justice. I have already submitted. And this is an online copy.
Oh, yes,
Sorry,
we
I
have
could
it,
not
we have it.
obtain this one online copy.
No, it's okay.
Para 50.
50.
50. I have put paper plate over the para. It was
Just
delivered by Chief
just-
Justice. Honorable Chief Justice Indira
Just-
Banerjee,
just-
who is
just-
returned.
Just give me 5 minutes. Okay, this will have some persuasive value.
Yes. And relevant, most relevant is observation is in para 53.
Yeah, I have read it.
I guess. Only in the case of infraction to the section 463 and section 80 of Indian evidence, 463 CRPC. Yesterday we have discussed on that sections.
Okay. You have made your point.
May I continue?
So now, Mr.
Yes.
Mo, you have to start.
Yes, my lord.
You are reading PW
PWD 5, my lord.
5.
Yes, my lord. PWD 5 is in page 66. Page 66. Married. The
Yes.
the prosecution witness number 5 is what he said is married. I know the accused person standing on the dock by name as Manojit Sonowal. Accused hails from my same village. I appear today on being summoned by this court. I Yes. One day when I was staying in the house of my uncle, I heard that one unidentified dead body was lying inside the bushes between Kauji Pathar and Bisa Agro Tea State. And accordingly, I went there and seen the dead body, which was in decomposed state. After some time, police also arrived. Inquest was conducted about the dead body. I have also seen that the doctor conducted post-mortem at the spot. So this prosecution witness also, he's not a direct eyewitness. Your Lordship. He just said that I heard. This is only hearsay, my lord. And then I will just come to prosecution number 6. Number 6 married. Sri Monica Bomji, age about 25. Yes, taken on oath on solemn affirmation of the provisions of Indian Out Act before me on 12th September 2017. Married. I know the accused person standing on the dock by name as Manojit Sonowal. One day when I, along with my friend Rina and Anita Bomji, were proceeding toward Bisa Agro Tea State, we came across bad smell on the road, and we noticed one unidentified female body lying inside the bushes in decomposed condition. We accordingly informed the matter to one Sri Jiten Bomji of Bisa Agro Tea State. Police also arrived and did activities about the dead bodies. So here also says that only the smell was coming out. So I don't know how they saw the dead body from the main road, because your national, it must be a main road. And then the PWD 6 says that the body was lying in the bushes. I mean, there is no such proof to show that why they have entered in the bushes and found the dead body. And PWD 7, my lord. PWD 7, my lord, is PWD 7 to 11, 12, all turn hostile, my lord. They say it is extrajudicial confession. PWD 7 is in page 69. I can married is Parojit Sonowal, married on oath. I can recognize the accused person standing on the dock as the Manojit Sonowal, as he was my friend. One day in the month of November 2016, myself along with the accused and some other attended a marriage party at the Kochari village. Therefore, police called us and recorded our statement. I was also forwarded to the magistrate for recording my statement.
No, here in the cross, he say, the magistrate recorded my statement. I never stated before him that the accused in the marriage party stated to have strangulated the deceased. The signature shown to me today is my signature. So this was one of the prosecution witness. And in the cross, and then next is my lord, prosecution witness 8 is in page 71. See the Borges on the wall. What he said is, I can recognize the accused person standing on the dock as a monologist on the wall. He hails from the same village. In the month of November 2003, we include the accused, including the accused, participated in the marriage party. And thereafter, police call us and recorded our statement. We will also forward it to magistrate for recording our statement. In the cross, it is not true to suggest that I have stated before the magistrate that the accused in the marriage party said to have strangulated his girlfriend. And the PWD P exhibit A 8A is my signature on the statement recorded by the magistrate. In the cross, I put my signature on my statement without knowing the contents thereof. So this is the cross, my lord. So he is also not eyewitness. The witness or he just say that whatever he said in the cross is a statement without knowing the content thereof. And then a prosecution witness number 9 is another friend of this three friends were there. The three friends, that's his name is Probal Sonowal. He also said I can recognize the accused person standing on the dock at Manoj Sonowal. He hails from my village. After recording our statement, the police, we were forwarded to magistrate for recording our statement. In the cross, cross is done by PP is yes. I will just read the cross by the defense. I put my signature without knowing the contents thereof. So that is the in the cross he said. And then prosecution witness 10 is in page 75. Numel Mura, married. The deceased Ratni Mura was my daughter. Though she was killed, I don't know who killed her. I was called at police stations, and when I have seen the photograph of my deceased daughter, at the time of offense, I was not at the station, so I cannot say who killed my daughter. I can identify the accused standing on the dock. This much I have to say. So this is the statement of the mother of the victim. And now the prosecution witness 11, he also married Sukaru Mura. Yes, exhibit 9 is page 73. Oh, PW9, exhibit 9, exhibit 9, okay. Exhibit 9. FSL, my lord. Exhibit 9, let's check. Exhibit 9, 3, 7, 8. It's in page, it is starting from page 37 to 45. 37 to 45. 7 to 45. Exhibit 5. It's page 42.
Mr. Taru, you just read this 7, 8, 9, and 10 PWs. Correct?
Yes, they all become hostile. These four witnesses.
Just come to, at random, we are taking up PW 9, page 73. Please come there. Page 73. Yes.
Yes,
Now, what is the statement which makes him hostile?
because these four witnesses also gave a statement under 164.
No, that's okay.
They,
No, here you see page 73, there are only 3 lines. These 3 lines are, I can recognize the accused person standing on the dock
No.
as Monojit Sonwal. He hails from my village. After recording a statement by the police, we were forwarded to the magistrate for recording a statement.
statement.
Now the witness is hostile.
Yes.
Now please tell us in these 3 lines, what is the statement which has made this witness a hostile witness?
Because
I can recognize a person standing on the dock as Monojit Sonwal. Correct? Is it false?
no.
No. So for this statement, he can't be declared hostile.
Yes, he
Number
was
2,
declared hostile.
he hails from my village. Is it false?
No, they are from
No.
the same
So for the
locality.
second statement also, he can't be declared hostile. Number 3, after recording a statement by the police, we were forwarded to the magistrate for recording a statement. Is this false?
No, it's also not.
Then how can he be declared hostile in these 3 words, 3 lines? It means with all respect to the assistant public prosecutors who are handling the matter or public prosecutor, they are not trained in the art of cross-examination.
Yes, it seems so.
I'm not making a personal comment. Please don't take it as a personal comment for this particular APP. But it appears that there's a lack of understanding as to what is hostile. You see, for a prosecution to request the court to make a, to hold a witness to be hostile, the requirement is that he must give a statement which is contradictory to his previous statement.
Your Lordship, in LCR, there are also 161 statement separately.
No, we are not, I'm not even come to the 161 statement.
And now it's become,
I'm just discussing the principles on which a person can be turned hostile. It says that a person, if he gives a contradictory statement to his previous statement, then he can be declared, a request can be made to the magistrate to make him, to declare him as a hostile witness. Now, these three witnesses, these three statements which he has made, these
Yes.
are the only 3 lines
yes,
when he's declared hostile.
without
Nothing is
having any
contradictory.
contradictory statement.
Nothing is contradictory. Therefore, I am right in making comment against the APP or APP who is dealing with the matter, that he was not aware of the principles when it can be declared hostile. Now we come to 161 statement or 164 statement, which is his previous statement. That is, you have shown at page 42. Correct?
Yes.
Now, the previous statement, the witness is not accosted with his previous statement. Accosted means you refresh his memory with his earlier statement. So ideally, I think that you should have, you, not you, Ms. APP, whoever is there, you should have addressed the court, put the witness the question that, look, do you remember your previous statement? Because you can't lead. When you are taking an in chief, you can't lead. That what was your that this after this, he was forwarded to a magistrate for recording a statement. Then your question should be, what was the statement you gave? After this only, this witness will say what statement he gave there, or he will say, I don't remember. Then you give him that document and say that please refresh your memory and now say what you have stated earlier. Refreshing a memory is possible. So then he tenders his previous statement. And end of the matter, there was no question of getting this witness declared as hostile. And after getting this declared hostile, what do you say? It is not true to suggest that the accusing party admitting to have strangulated the deceased girlfriend. Now this is your suggestion, he has denied it. Now your evidence is against you. I think when you have
How
advantage-
witness was declared hostile, it's even
No, but you
myself
see,
is not clear
in
for
his
this record.
examination chief, he has not even denied that.
Yes.
Now, as in his cross-examining, you elicit this answer. You means whoever was there elicited this answer. Therefore, when the witness was not a hostile witness, you made him declared hostile and you got a statement which goes against the prosecution. So I have a feeling that when you have the advantage of Mr. Habun being here in this court, I think you should have a training program and invite lordship to deliberate with you as to the art of cross-examination or art of examination.
Yes, that will be.
You'll have to do it if the prosecution wants to succeed. You'll have to have an online training program of some sort. Because these 3 witnesses are the witnesses who were on the extrajudicial confession. This goes.
Yes.
If this goes, what is the evidence left out? Then you say that 164 statement is the only confession we have.
This case in hand is entirely on the basis, conviction was done on the basis of circumstantial evidence and corroborated by 164 statement of the accused. Earlier it was extrajudicial confessions of these 4 persons. Now they retracted during deposition statement.
They did not retract.
They have become hostile.
That's what I'm asking you. I'm showing you this page and I'm asking you, what is the statement which made them hostile? There was no statement at all. There's no, he was not confronted with his previous statement. And you got him declared hostile. You means the PP was handling the matter then, declared him hostile. And after getting hostile, declared him hostile, he just asks that question and he gives this answer. The previous statement was not even put to him.
Here, Your Honor, in chief, these four witnesses were not revealed about their statement given under 164. So that might be the reason why PP has.
You see, that is an art of examination. In the art of examination, a witness must be put questions which are not leading questions, and yet it will elicit an answer.
In chief. Yes.
Correct. So that's what I'm asking you. You see, that is for the time being, what you call, dramatize this matter. We say that you are this witness, PW9, you are PW9. We dramatize and I assume the role of the lawyer, APP. And now I ask you the question, can you recollect what is your previous statement before the police and to the magistrate? You will either say, no, I don't know, or you will say that, yes, I remember this statement made and this was my statement. And if instead of saying that, he uses the third option, if you say that I told before the police that I don't know anything about it, then you get a, what you call, a right to ask the court that, look, in the previous statement he said that, now he's denied it. You said, you show in this exhibit 9 and say that, look, in exhibit 9, this is the statement you have made. The witness says, no, I did not make it. Then you pray before the court that he is an hostile witness. And then you ask questions.
Yes, exactly. That is the procedure.
Correct.
Yes.
Because
sometime here in our state.
In the last deliberation also with the bar which I had, where I had referred to the Evidence Act. And I normally say that I don't know whether I don't remember whether I used it or not here. But in the art of cross-examination, the art is to know what questions should be asked and what was the possible reply. So, by leading a witness to an answer is an art. You must, unless we accost that, because you see, this exhibit 9 does not come from his mouth. He does not exhibit exhibit 9. That means you are exhibiting it through IO. IO is a witness post witness number 9. Post means IO was not examined before PW9. Therefore, his previous statement recorded under 164 before a magistrate was not even evidence before the court at that point of time. It could not have been, you could not have, or ought not to have, without accosting without confronting him with the previous statement, got him declared hostile.
Probably court might have also, of course, since the court has allowed, probably he denied the statement, but then it hasn't come on record. That is why that has to come on record.
The record seems to be incomplete.
No, you can't allege it now.
No, I'm.
No, you see, because of the fact that at that point of time you did not take steps
I'm
to rectify.
So
therefore, it's quite possible. My brother is absolutely right. That might have happened. But you see, why I'm questioning you is the fact that exhibit 9 was not even exhibited when PW9 was examined. So the proof is post examination of PW9, and therefore, when I am reading this statement of PW9, I find that this man has been declared hostile without even that previous statement being brought on record.
A similar statement.
For all these four. And therefore, the confessional statement goes lock, stock, and barrel. It has to be discarded. So therefore, this is a part of my endeavor to tell you that you should interact with your own BPs and APPs through the Director of Prosecution or the Secretary Law, whoever is there in charge of prosecution, to organize a meeting and then upgrade your skills as a public prosecutor. This is just my thought. I'm not advising you, it's just a thought process. This has occurred to me, and it's for you to take a call whether you need upgradation of skill or not. Correct?
Yes.
But I'm compelled to say that because I find that there are compelling reasons for me to say so. Okay, we'll resume tomorrow again. There's a single page again. We'll resume tomorrow.
Obliged.
Supplementary one, I just wanted to withdraw this.
Which one? Okay, this application.
With the liberty to file a fresh.
Okay, let me see that.
This was for modification of bail order, Marat. So it was directed to be listed before appropriate authority in July, Marat. Because your lordship was outlined bench and the constitution of that bench, Marat, we don't know when it will be constituted. So we'll better withdraw this matter from here, Marat.
Okay. Mr. P. Tafoda, counsel for the petitioner. This Nia, who is there?
I have informed Mr. Tapin was there, Marat. We have just gone to his hometown. I informed.
Mr. Tapin. Can I record his presence?
Yes, I informed him.
Hello? Yes. Can I record his presence? And as well as the senior public prosecutor for Nia. So upon instructions, the learned counsel for the petitioner seeks to withdraw this application and to approach the court again. Prayer is allowed. This criminal petition stands closed with liberty as prayed for.
Obligement.
Lordship, item number 8, Lordship.
Yes.
Lordship, I may be allowed to withdraw with liberty while approach this honorable court as
That
per.
would be better.
Lordship.
That would be better.
Lordship, I'll file a leave to appeal, Lordship.
Definitely, definitely. This leave application, where is that application? That file again?
IA 163.
That is a leave petition. This is a leave petition.
It's a IA, Lordship, in writ petition or writ application.
Mr.
J. Ginny, Lordship.
J. Ginny, learned counsel for the applicant. Mr. M. Kato, learned DSGI, and
MS
Ms. Anju, learned counsel for
Respondent number 456.
respondent number 456.
Lordship.
And you are also there, Ms. Arbasar, learned government advocate appearing for respondent number
1 and 3.
1 and 3. The learned counsel for the applicant seeks to withdraw this application for impleadment by reserving right to approach this court in an appropriate in such appropriate manner as the application may be so advised. Full stop. The said prayer is allowed. This impleading application stands closed with liberty to the applicants to approach this court if independently if so advised. I think that was a better decision because of the fact that we might not have allowed impeding, but we might have allowed you being an intervener. But then you would not have right to address the court. You can only see that nothing goes against you. So your appearance before the court would be only limited. Principles of what call this intervener. You perhaps know it. Yes. So I think that's a good decision otherwise. Yes.
Obliged.
So 2 o'clock will resume at single bench.
Much of it.
20 and 31 to 37. These are analogous matters, my lord. These are termination matters from the APPSC fiasco, my lord.
Okay.
So, my lord, in some of the cases, we have filed our affidavit, but we are yet to file our affidavit in others.
If it is similar, you can rely on one.
No, my lord. These are different departments.
Okay.
Different department, different posts. So can it be taken up on fixed on
No, but
20?
You see, but the problem is that these are all 2014 matters.
No, my lord. 23 matters.
No. Of the year 2014.
On
I don't know. It's written
no
259 of 2014.
9 to 20.
Oh,
Item 9 to 20.
Okay. 9 to 20. Okay.
And 31 to 30.
Okay.
30.
You have consent of the other side?
7.
You've
Yes,
taken
my lord. I
consent?
have taken consent.
Okay.
Appearing in item number 15, and there is the interim pair.
Uh,
So it's interim, so interim may be-
Interim order, those already there in the cases, that may continue. Some there are no interim orders.
No, but then you have to tell us which cases there are interim orders.
My lord, I'm
Item number 10 and 15, interim order is there.
Just take a note, 10 and 15
10
interim
and
order.
15.
Wherever there are interim order, please indicate to my secretary so she can write it down.
Yes.
Otherwise, in adjournment petitions, we will not open the file and read it.
Yes, my lord.
Correct.
We will.
Okay.
And
All
then,
sides are- all parties are duly, both sides are duly represented on the prayer made by Mr. Henderson, counsel. You're appearing as?
And out of this, my lord, item 33 may be segregated
No, you're appearing as?
as the additional AG. my lord, for the state.
Additional AG of the state pays for adjournment. So as to enable him to. Why this file to examine the records and file affidavit in opposition, if not already filed. The next word would be, next line would be that interim order of past case and extended only in those cases where it is there. Huh? Okay. This is item number 10, 9 to
9 to 20 and 31 to 37.
31 to 37. Are separate orders. Huh?
My lord, here item 33.
Huh?
This is an another. This is to be segregated. Item 33.
It's a different matter.
Yes, ma'am.
So let it remain in the record. We'll when we reach there, you tell us. You filed your affidavit.
Yes, ma'am.
So then we can.
33 and 34, man, there are interim orders, man, that request.
No, 33 and 34, if it is not it's not a bunch, a matter of the bunch.
34
then we
is,
take it up.
No, 34 is there in the bunch. 34 is there.
No. You said just now the 33
33
is not there.
33 is
so
not.
33 take up. 33 means the banging is there.
Yes. We'll take up on that. Let it be.
33 he says is not the matter of the group.
My lord.
So if it's not there, then we take it up.
Not today, my lord.
Not today.
Similar matter, only the
Same set of almost fact department is different. Question of law is same.
No.
But
This
you
is
see,
different.
I don't know. I have not applied my mind. But
that is
additional AG says that it is a separate matter. It is
These
separate. It is his prayer. It's a
Yes,
separate matter.
separate method because these are from the APPSC. And this item 33 is of APSSB. State Selection Board, and this is Public Service Commission. Rest are Public Service
Okay,
Commission.
33, you add one extra line. The learned additional AG submits that this matter may be taken up separately.
Separately.
From batch of other cases where the where the selecting authority is APPSC.
This is
And-
pertaining to APSSB.
And in this case, the
By the time we'll find whether we get or not. Okay.
the selection was conducted by
PSSB, Arunachal Pradesh Staff
APSSB.
Selection Board.
Next para. The said prayer is allowed. This repetition shall be taken up independently.
Independently.
List
After a week.
after
2 weeks.
after 2 weeks. All other matters also after 2 weeks.
After all other matters on 20 December.
I
20.
33 minute, there was an interim order that.
Okay, 33 interim order extended till next date of listing. List on 20/12/2023. All the matters.
Published. My lord, in this series methods, there are some interim orders in some cases, my lord.
Okay, tell the numbers.
34, there is an interim order
34 interim order. Then
that needs to be extended.
okay. Any other matter, please tell it to the.
Oh, they have prepared a list, man.
Give it to my secretary, otherwise it will be.
Yes,
missed.
yes. Oblate.
Okay. Yes,
Item 38.
30,
Well,
7.
no. This is item 31, my lord.
31, yes.
31, brother Tapin is not there. Well, kindly fix this matter tomorrow in the admission column.
31, it's a matter of group.
No, a single matter.
Yes, okay.
There is some urgency, my lord, that NOC has been withdrawn.
31.
31 tomorrow in
You are
the.
there.
Yes, I am there.
Lordship, S. Tapin has some difficulty today, Your Lordship. So
Watch out for the
tomorrow-
comment. Okay,
Yes.
okay. I was thinking that you were led. You are being led by him. Okay. What says I represented on the prayer? Miss.
You know.
Arbasar, Your Lordship.
Anira is
Basar.
Basar, Your Lordship.
Learned commented today. Matter stands adjourned today. List, give it date of tomorrow. Tomorrow is
tomorrow,
Seven.
in the admission column. my lord.
7. Okay.
And that the interim order is there. That to be continued.
Interim order stands extended till the next week of listing. 31. Okay.
Grateful.
Lordship, I would like to mention item number 39.
39.
Your Lordship, I have taken the consent of the petitioner, Your Lordship. Kindly take up this matter after a week.
39.
39.
Okay. With consent of the other side, Ms. R. Basat, London Government Advocate, pays for adjournment. It is allowed. List after a week. Okay.
Obliged, Your Lordship.
Made to the laws. Beg to mention item numbers 40 to 44 hearing matters. I've taken the consent from the other side.
Yes.
Can this be taken up on 13th of this month, man?
40.
40 to 44, my lord.
40.
40.
244.
4 to 44.
Okay. You're taking consent of the
Yes,
consent
yes,
council?
yes.
With consent from the from our consent council. Mr. D. Pani, Planet Council. In WPC 290/2020, place for adjournment, prayer is allowed. List after.
13, my lord. 13 of this month.
List on 13/12/2023.
Oblate.
May I, Your Lordship? I beg to mention item number 38, Your Lordship.
Yes.
This matter may be listed after 3 weeks, Your Lordship. Supplementary hearing.
No, 38. Just wait. I have to see the record. But it's a 2015 matter, I'm finding it very difficult to adjourn. 15, now we are in
Yes, Your Lordship.
8 years.
Yes, Your Lordship.
No, I think we'll take it up, then we'll see.
We were supposed to produce the record, Your Lordship, till we have not received, Your Lordship.
No, then you see, if the government does not get the records,
Yes,
but has ordered eviction, we state permanently, we remand the matter back for a fresh decision.
Lordship, as per the order dated 12/12/2022, government was supposed to produce.
But if they don't produce the records, what do you do? We take
Lordship.
adverse what do you call inference and proceed. 2015 matter, I can't adjourn like that.
Lordship.
There's also a judicial order. It says that this whole pending case will have to make an endeavor to dispose it of. So if unless you challenge that order in appeal to a higher court than us, you can't adjourn it. It will amount to disrespecting the previous order of this court. So this is I'm refusing. Take it up. If you can't dispose it of, then we'll see if it can be adjourned.
Your Lordship, again, I'm going to mention item number 22, Your Lordship.
23.
22.
22, yes.
This matter may be listed after 2 weeks, Your Lordship. Here we are supposed to file our counter affidavit, Your Lordship.
It's a 21 matter.
Yes, Your Lordship.
You've taken consent?
Yes, Your Lordship, I've taken consent. Our affidavit is almost ready, Your Lordship.
Okay, with consent of the other side, Ms. P. Pangul and the government advocate place for adjournment for enabling the concerned respondents to file, the state respondents to file affidavit in opposition. To stop, it is, the matter is adjourned. Giving the respondent authorities a last chance to file their affidavit in opposition, failing which the court shall invoke the doctrine of non-favors and proceed to hear the matter by presuming that the respondents have admitted the claim of the petitioner. Just after 2 weeks. Yes.
May Your Lordship, I beg to mention item number 21. Lordship, I have taken consent from the respondent.
31. Somebody had already paid for adjournment for 31.
21, Your Lordship.
21.
21, yes. The conducting council here is having some health issues, so matter may be adjourned for today and fix on this 14th of December, Your Lordship.
No, it will go to 13th, not 14th. On the ground that the conducting council has some is unwell. Miss
A. Talom.
A. Talom, counsel for the Island Council, place for adjournment is allowed.
Your Lordship, sorry, interim is there, so interim we can.
List on 13/12/2023, interim order passed earlier stands extended to the next date of the state. Okay.
Okay.
May I, Your Lordship?
Yes.
Your Lordship, I may be allowed to withdraw this
You
petition
will withdraw this.
with the liberty to file press.
No, you can't get liberty because this is a cancellation of bail. You file a revision against that. Liberty you won't get without informing the court why. What is the formal defect? You see, the liberty to withdraw and file again. It is not there in the CRPC unless you can show me. It is there in the CPC order 23 rule 1 and 22 rule 1 3. But criminal petition, you want to withdraw and come again. You will have to show us some reason.
But your lordship, there is a defect in the petition, that's why.
What defect? Tell us what is the defect.
Your lordship, actually the conducting counsel is appearing on court number
We'll take
2.
it out after some time. You be prepared. We'll take it out after some time. When you are ready, tell the court master. We'll take it up. Matter.
Much obliged.
Your lordship, here file the petitions.
Okay, I'll issue a formal notice.
Yeah.
It's a matrimonial dispute settled.
Yes, your lordship, my only difficulty is with regard, since they are only here with on the ground of compromise, your lordship.
I'm issuing a notice. I can't do it in motion stage. I can't allow a revision.
Yes.
Correct.
Yes, your lordship, this is the matter of the husband and wife.
No, I understand, but in motion I can't do it without giving notice to the state.
Yes.
Correct. Well, Mr. T. Gaddy, counsel for the petitioners, and Ms. T. Ginny, done an APP for the state. Next. On the ground that the matrimonial dispute between the parties have been amicably settled, by filing this application under section 482 CRPC, the parties to the matrimonial dispute have prayed for quashing of the proceedings of WPS number 15 of 2022 under section 498 capital A oblique 326 oblique 506 IPC. If you notice to the respondent state, returnable in 4 weeks. Requisite extra copy of the application be served on the ground to enable her to obtain instruction. You have the projection of a compromise in the matrimonial dispute, the further proceedings of SEPA WPS case number 15 of 2022, corresponding to GR case number 78 of 2022. Where is this pending? Before which court?
Your lordship.
This matter is pending before which court?
Yes, CGM SEPA, sir. CGM SEPA.
CGM, where have you stated that? Where have you stated that?
Lordship will see the last page number 28.
Page number?
28, your lordship.
28. The Court of Chief Judicial Magistrate, East Command District, SEPA shall remain state. Subject to condition that the petitioners shall produce a certified copy of the order before the said learned court to bring the order to the notice of the said learned court. This after 4 weeks. P. Yes. Yes, you've got instructions.
Lordship, nothing proper, but then they have only said that they have furnished the order on 4/5/2023.
They will
They are received that only They are received that only they have lordship.
Please pass it on. Please pass it on.
And lordship cancellation order 17 May 2023. Only that much. Lordship. And it's 1 page 23 lordship.
Page
Cancellation
27,
order is page 23 lordship.
23, yes. You see, I don't know the procedure under this Arunachal laws. Can I pass you over the CPC?
Lordship, otherwise also,
No, no, I'll
lordship,
show you
they
something.
could, if they are agreed, they could have
Yeah,
a.
give it to her. Give it to me, Seti. No, I'll show you something because since I don't know the what you call the nitty-gritties of the laws of the state, especially regarding to cancellation of LPC, I'm showing you this CPC. Please come to Order 26, Rule 10. It is in the right side of the page, Order 26, Rule 10.
26, no?
You got it?
No.
You got it?
Yeah, I. Pichik, नहीं. That's the whole thing.
You got it? Order 26, Rule 10.
Lordship.
Now you see Order 26, Rule 10(2), which says report shall be evidence.
Lordship.
Commissioner's report shall be evidence. Correct?
Lordship.
Now please read that. Commissioner's report shall be evidence.
Report of the commissioner and the evidence taken by him, but not the evidence without the report, shall be evidence in the suit and shall form part of the record.
Correct. Now you see what happens is that if an ex parte report is created and it is submitted on the orders of the court, it becomes a report of the commissioner and it becomes admissible in evidence. Now the question to you is, can you create an evidence without the party being present? There are two parties in our proceeding. Now, can a report be called for and made evidence in the case without the other side being present.
Lordship.
Or otherwise, when there is an order of the court to proceed ex parte against the defendant. If there is an order of the court saying that we proceed ex parte against the defendant, or here to the petitioner, then we can understand that there is an evidence which is ex parte and it is admissible. But without holding someone to be ex parte in the proceeding, the question is very simple. Can an evidence come on record or permitted to be come on record? It can't.
Lordship, if the petitioner is aggrieved, Lordship, they could have a appeal also to the secretary, Lordship.
Oh, don't tell us those things. These are,
Lordship.
you see, I'll show you. Come to section 105. Section 105 in the first part.
Yes, Lordship.
Yes, what does it say?
Save as otherwise expressly provided, no appeal shall lie from any order made by a court in the exercise of its original or appellate jurisdiction, but where a decree is appealed from, any error, defect, or irregularity in any order affecting the decision of the case may be set forth as a ground of objection in the memorandum of appeal.
Correct. So if there is an interlocutory orders passed in a suit or a proceeding, every order is not required to be put into appeal. This is first. Second, appeal is a creature of statute. So statutes must provide that all orders are appealable. If it provides that all orders are appealable, then I can understand your contention. So please show us from this LPC which act is created, and whether that act provides that every order shall be appealable.
Lordship, in that case, Lordship, we may be directed to Lordship.
Produce the records. And who is appealing for the private respondent? You are there.
My left, yes. My left.
What do you have to say?
Under the Arunachal Pradesh Land Settlement Record Act 2000, it is any order passed by the, it is appealable now.
No, sir.
Volume 7. Section 83. Page 227.
227.
It is start from 202. Relevant section is page 227. 83. Section
227. Section?
Section 83.
83.
Yes, sir.
I think we have a new book. This is a 2018 book. Which act?
Arunachal Pradesh Land Settlement and Record Act 2000.
Page 4.
In my book, volume 6, volume 7, it is page 202.
Just a moment. Arunachal Pradesh Land Settlement Act 2000.
Yes, sir. Land Settlement and Records Act.
Section?
Section 83. 83.
Yes, Mr. Sonar,
My lord.
if that order is appealable,
My lord.
maybe
here-
we should entertain a
Yes,
petition
for that,
against
my
that.
lord, I have a submission, my lord. My lord knows that the settled proposition of law, that just whenever the, my lord, violation of the principle of natural justice is concerned, violation of the fundamental right conferred under Part 3 of the Constitution of India, alternative remedy, my lord, cannot be barred for filing the writ petition so far, my lord. There's a series of judgment in that. Here is the case, my lord. It's not the case completely, it's the violation, it's on the apparent on the face of record itself, my lord. There's a violation of the, my lord, principle of natural justice, my lord, the minimum requirement.
You see, you have appeared in the proceedings.
My lord, I appeared. My appearance is while I have been asking, my lord knows that I have one citation also, my lord, that not only furnishing of complaint is not required. Even if the complaint is furnished to me, even if suppose assuming, my lord, even the report is furnished to me, everything is furnished. But still, my lord, that elements of fair, this principle of natural justice will be violated if I am not provided the opportunity to cross-examination those witnesses on the basis of which statement the LPC has been cancelled, my lord.
That is a hypothetical.
No, my lord, this is
situation.
the judgment, my lord, I have.
No, no, no. In this case, it is merely a hypothetical situation. You have not prayed for cross-examination. So question of allowing you to cross-examine will not come.
My lord, hypothetical in the sense, my lord, here is the question, no complaint has been given, my lord. It's the admitted position, my lord. Now my lord, specific query was that whether complaint copy has been served to me. They could not produce me. Apart from, my lord, inquiry report has been used against me. Some statement has been used against me, my lord. Not the, my lord, single copy, nothing has been given to me, my lord. So, and my lord, one more thing, my lord, so far, in charge, question of in charge ADC, my lord, that part, my lord, this, our Honorable High Court single bench house already endorsed the view of the Karnataka High Court, saying, my lord, that, yes, my lord, in one of the case where I argued, my lord, right here, where, my lord, that departmental proceeding was initiated by the in charge. That has been quashed relying on the Karnataka High Court judgment itself. There are 17 and 19, my lord. My humble request, my lord, if the government is saying, my lord, that complaint copy has not been served to me, my lord, then this entire, my lord, it has to be, my lord, reheard, my lord, fresh proceeding has to be initiated. And to, my lord, tomorrow, even, my lord, if additional in charge deputy commissioner, even if he issues, my lord, that question will always remain, my lord, whether has the authority or not. My lord, may I take two documents, my lord?
Just a moment. Just a moment.
My lord.
Yes, anything more you want to say?
Fact that, my lord, he has appeared, my lord, it is admitted fact, my lord. He has appeared, my lord, pursuant to the notice issued by the concerned authority. And there is a, my lord, the other neighboring event, they say that although in my submission, my lord, he has no plot of land at all. The land, whatever land is, belongs to my father. And everybody nearby, everybody locally they knows. Deceitfully and fraudulently obtained the LPC. And even my brother, Tanam, against his name, he also applied, issued LPC. After knowing the fact, my brother has lodged complaint before the concerned authority, issuing authority, that I have not applied. By forging my signature, petitioner has applied. Therefore, that LPC may be cancelled. Otherwise, you will be misused. This was having seen this all fact on the submission, on the written submission, written letter of my brother, his LPC was also cancelled because LPC was not in his possession. It was in the possession of the petitioner. Now the petitioner he has no plot of land because that area is at Balijan, Holongi. And Holongi, it is far away. Now, you see from his affidavit, he's from Le Purian Circle, he's from more than 100 kilometers away from the place where the land is situated. And we are from that very area. Now, in this aspect, in fact, even other the neighboring, they have also said that, well, obtaining the LPC signature is required. That signature, that obtained, admittedly, it's been obtained by forging. It has not been obtained, it has been forged, signature has been forged. And some of them fraudulently they have obtained, the order itself is reflected.
Who has admitted, the petitioner has admitted that?
My lord.
The petitioner has admitted
My lord,
forgery.
that forging part is not admitted, but so far participation, knowledge of the inquiry being held, and it's his in knowledge, and he even appeared also. Pursuant to the notice, my lord, he appeared also. Pursuant to notice dated, my lord, 12th December 2000, he appeared also. At page 27, my lord, the notice, my lord.
While you are reading page 27, I have read page 28 and 29.
My lord.
In
My
page
lord,
29, he says that give me a copy.
Okay, my lord, you see, my lord, the page 24 onward is LPC, my lord. LPC has been issued on what basis? My lord, this is second paragraph. This certificate is issued on the basis of no objection certificate issued by Nabum Kanam landowner. My lord, Nabum Kanam is my brother, my lord. He had purposefully, my lord, fraudulently, in order to get the NOC, if this even he got issued the LPC in the name of my brother. After later on, after having come to know my brother's submit application return, it has been cancelled, mother. Now, now this all they have given their statement, written statement, and at page 35, this issued based on manner, no objection certificate issued by Naval Noku landowner of North Side Manor, Kumar Y landowner. Now, Kumar Y landowner Manor, he specifically in written, he stated that he has not signed and his signature has been forged. Manor, likewise, Manor, this entire Manor, this now again, page 26, Manor, this is my brother's LPC. Against which my brother's lodged complaint that has been got cancelled. It was LPC was in his possession, madam, petitioner's possession, and it got issued in the name of my brother without knowledge, madam, forging the signature of my brother, madam. This is madam, and for that NOC he himself petitioner he himself issued, madam. No objection certificate issued by Sri Nabam Sadiq, madam, landowner. This is in respect of my brother, madam, at page 27. My lord, and my humble submission, my lord, this the issue he has raised, my lord, this is all, of course, is a disputed fact, my lord. If he has a really genuine, my lord, if he can submit his claim, he ought to have approached the civil court, my lord. The disputed fact cannot be gone into by my lord when examining this proceeding. Is the case of title. My lord, just only I like to, my lord, regarding disputed fact, my lord, and also just on disputed fact, my lord, that's small. There are 11, my lord, just a highlighted, my lord. So, because disputed fact, my lord, although my lord, land belongs to me, my lord. Disputed fact, and I also it's one of the my ground, and again, my lord, the LPC, my lord, that has been obtained fraudulently. If my lord is not, my lord knows, my lord, in Papaya Sastry case, my lord, any order obtained by playing fraudulent manner, it vitiates everything. It's become non-essential law, be it before the honorable court of the any authority. That manner, 2007 court.
No, not required. You say so, we will accept it.
Yes, madam.
But that is well settled. We accept it. But you see, it's just a question of someone looking from a particular spectacle.
Madam.
I use a bifocal. So if I read something from the lower side, it has a different effect. If I read it from the upper side, document which is so close, I can't read anything. Correct?
Madam.
So there is that is my shortcoming. But you see, what amounts to disputed fact is something. If I go into that dispute, then it becomes a question of adjudication of disputed fact. But if what the petitioner says is correct, that he appeared, he asked for a copy, he is not given a copy.
Madam.
He repeats that prayer for the second time, which is annexed to this writ petition, saying that please give me a copy. And then the proceedings are taken up without service of copy.
Madam.
What is the disputed question of fact here?
Madam, that part, madam, I agree with that. Now, madam, my humble submission, madam, since there's a statutory appeal, madam, we also have resolved that part. They have not done. It's not that. It's not for the appellate. That's also one part of one leg of it. Second, my lord, my lord's interfere with me. Now, as I have highlighted, he's so powerful, and this respondent, is orphan, helpless. Father died 2007, and helpless and taking advantage of this helpless in orphanage. This thing that is property has been captured, even not only the immobile property, even movable property also. Now my apprehension, if once that LPC is in his position, at any cost, he will try to dispose of and eliminate the private, respondent and orphan matter. That is one of my serious apprehension. If because of the procedural lapses, so that the minor is considered that part taken into account that safeguard for the property.
My lord, there also I was condemned unheard. Here also my friend, without having any materials, giving any record, my lord, here also he has been condemning me, my lord. My lord, the fact, my lord, is that, my lord, let's understand, my lord, what is LPC actually. LPC is not a title document, my lord. LPC, my lord, is basically issued to a person who is in the possession of the land. My lord, here is the case, my lord. After the demise of my younger brother, these kids, my lord, they were kids, they were aged 8, 7, 6 years at that point of time. It was me. I brought up them, educated them. After now, they are gainfully employed. They left the house. You know, I am not coming to, because we are not here, my lord, coming to all those things. Because my question is, I am not asking for anything. My lord, only the issue is, my lord, whether I have a right to be heard or I don't have a right to be heard and to be condemned that I have forged without hearing them. Basically, my lord, this is when my lord will see. That is only the question, my lord. My friend is, my lord, making this, and my lord knows section 114E of the evidence act says, my lord, whenever this official document is issued by the government, what is, my lord? LPC is not issued mechanically.
No, it says every official or judicial work is
presumed to be, my lord,
presumed to be
done in a correct. Now, once after verification, that presumption is still there. Now, that presumption has to be rebutted by, my lord, putting the, my lord, evidence, my lord, in the proceeding, my lord. And my lord, may I take, my lord, to the Impugn order itself, my lord. May I take, my lord, page number 23? Now, my lord, we'll see. Question comes, my lord, whether the additional, for a moment, my lord, I will even consent, let's in charge has a authority for arguments. Let's see, my lord, whether he has used his mind or not. I will just read out his operative question. Last paragraph, my lord. Now, let's see, my lord. As per the findings and recommendation by Sri Rome Emily CO Balijan Tarasaro, inquiry officer, and as frequent notice served to Sri so-and-so, and further opportunities served on being, I hereby cancel the decision. What exercise he has done, my lord? What is the ground he has cited, my lord?
He has read it.
My lord, he is saying that as if the inquiry officer is the authority to recommend for the cancellation, my lord.
Yes.
My lord, even this is the how this, my lord, I will say, my lord, why this has been cancelled. This has been cancelled only on the basis of, my lord, I will just take to the application, my lord, request, my lord. Enter page number 33, my lord. Here is a, my lord, clan-based organization who is in support of the other party, my lord. Page number 33. They writes, my lord, on 15th April 2023, my lord. Page number 23, Annex 7. Earlier also, my lord, this mail could not be held because of their intervention. Now, on 15 April, he writes to the Deputy Commissioner. I will turn to the, my lord, operative person, page number 34, my lord.
No, not required. These are beyond the point.
My lord, just I am
Page-
showing, my lord.
No. You see, page 23 does not consider page 33.
My lord.
End of the matter.
My
You
lord.
can't go into those.
That's my lord, not required. That's why I know what I have done for the upbringing. I think they should be thankful to me rather than criticizing me here.
Two people I can't hear together.
This part I strongly object, my lord. It is.
Two years given to me. I think 2 years are given to me to hear from one side and to take out from the other. It is not given to me to hear from both ears.
Well, I'm asking,
Upbringing or it's part
I'm
of the-
asking, hear me only before cancelling.
My sibling, my lord, and my son, it is absolutely false. The moment my father died, he came from Lepurian.
We'll file different titles with my lord.
Now,
Again, same thing.
My
If
lord.
I'm hearing him, I can't hear you.
now, upbringing, it is absolutely false, my lord. If it is the case, why the sentiment of the orphan that has been the undue advantage is taken? Now, this is absolutely false. Now, with regard to the since 33, 32 is a reliable. Just for my lord, just for information, my lord. This is here in a tribal society. You know what happened? They have this petitioner belongs to this clan. Whenever there's a dispute, my lord, it is family. They are the affects family member. my lord.
Any law which says anybody can poke his nose anywhere.
My lord, that is if they do not accept this, but think how it is there, my lord. He's from his clan is Nabam, and he's the Nabam.
No, you see, we read newspapers every day.
My lord.
Every day when you do something, when you construct a bridge, there is an objection that the bridge is constructed here. It should have been there. If no bridge is constructed, again, there's a complaint that why the bridge is not there. If the land is required for the bridge, then there's also a complaint why land is acquired here. So for everything, we have people who have poked their nose in. Is there a law in this land which says a clan, if somebody is prejudicially affected in their clan, the society can come in representation?
Practice is being prevented.
We can't take judicial notice of that. We can take judicial notice of only those facts which are ingrained in section 57 of the Evidence Act. Have you ever read it?
Madam.
You have read it? No.
My lord, one citation, my lord, where it says, my lord, cross-examination is part of the principle of natural justice. Not only, my lord, furnishing is not there.
I don't know. For that, you'll have to go to that appellate.
My lord,
appellate
well,
forum.
I will, my lord, only let me give the opportunity, let them decide the additional deputy
You
commissioner.
have to go to appellate forum. If
My-
appeal is provided for.
My lord.
Even if this, even if you are not heard, still the appellate tribunal would not be powerless to deal with the issue. It would not be maintainable.
My lord, that's my lord, series of my lord says, my lord, when violation of principle of natural justice. my
We'll
lord,
record that.
that-
We'll record that.
My lord.
We'll record your submission. And there will be an interim order that this LPC cancellation will not be affected for this giving 3 weeks time to the petitioner to file an appeal. What is the limitation? So limitation is how much to file appeal?
My lord.
What is the period of limitation
My
prescribed to
lord,
file
it's
appeal?
over, my lord. 1 month, my lord.
How much time?
30 days.
30 days. When was the order passed?
It was filed, passed in my lord.
May.
17 May.
May, my lord.
17 May.
Yes.
Is there an application for conversion of delay applicable here?
My lord, principle it will be applicable.
No, my lord, in the act itself, the limitation has been prescribed, my lord.
Where is it? Which section?
I think 68.
No, it doesn't say limitation. It says 84 says no appeal shall lie after 30 days.
Yes.
Limitation is not there. So it's
Condonation part that is not there.
non-obstante clause. Give me the limitation act.
My lord, 84, my lord, 84, my lord, it is mentioned, my lord.
84 I have read it. It's non-obstante clause. No appeal shall lie.
Correct. My lord, here in my lord, next page, my lord. In computing the above period, my lord, time required to obtain copy of order appeal against shall be excluded, my lord. Now it is up to when he have applied, my lord, when he has obtained them, that will mal count.
23 is not applied for copy. That limitation, if it has been served, will operate.
And my lord, I have raised some legal point of law also.
I'll deal with it.
And
That
my
will be
lord,
referred
my,
to the,
my prayer, my lord,
that will refer it to a larger bench. But this
my
bench
lord, at
will.
least my lord, this state notice may be issued, my lord. Then my lord, status quo
No,
as on today, my
we are
lord.
not, we are not keeping it pending here. That the issue which you have raised about in charge, on that will frame and refer it to a larger bench for a decision. For that, because in principle, I disagree with the Karnataka judgment for reasons I have assigned yesterday. That I'm not persuaded to accept. That is one. Second is that issue can be kept pending for a decision by a larger bench as to what would be the status of an in charge. And insofar as your application is concerned, will permit you to file an appeal, and without laying down a law in view of section 29 of the Limitation Act, I said that in this case, without this being a precedent, we allow you to approach the appellate court, and the said court will entertain an application. So, because of section 29, I will say that this is not a pending precedent. Let it be decided in an appropriate case, not here. But we'll remand it back and for this for 3 weeks, that is 21 days, we suspend that operation of the cancellation of LPC.
Much obliged. And my lord, that maybe observe my lord that property may not be disposed of, my lord. In case it's my lord.
Heard.
In the status quo of the
Sunat Leonard,
status quo of the
counsel for the petitioner, also heard the G8 and government advocate appearing for respondent number
5 months.
5.
Yes, ma'am.
No.
What?
Ms. Ete is for
Lordship, I am for,
1, 2, 3, and 4.
no, Lordship. 3 and 4, Lordship.
For 3 and 4.
Yes, sir.
Who appears for 1 and 2? Land management. Okay. Serially, Mr. M. E.T. Ete, and counsel appearing on behalf of Mr. D. Kamdok, standing counsel for Land Management Department, representing respondent number 1 and 2. 3 and 4 will be here, and for 5, Mr. T. Tagum, and advocate appears for appears and accepts notice for respondent number 5. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the office order number, page 23, dated 17/5/2023, passed by the additional deputy commissioner within bracket in charge. Sorry, in charge ADC Balijan, within bracket respondent number 4, by which the following 2 LPCs issued in favor of the petitioner was cancelled, being page 23 last. Next paragraph. The learned counsel for the petitioner has raised objection in respect of the said order on the ground that the said order was passed by the in charge ADC. Where is that earlier judgment?
Yesterday, passed by my lord, our court, my lord.
No, that earlier judgment you gave us, where was that? You have a spare copy, because I think we
The Karnataka High Court, my lord.
Karnataka High Court.
Yes, I have a copy with me.
Please pass it on.
Yes. 2 judgments.
Check if it is here. No, here, this. Okay, Karnataka. I think I have misplaced it. In support of his submissions that except for day-to-day work, statutory duty cannot be performed by an in-charge officer, the learned counsel for the petitioner has relied on the case of B full stop N full stop Bhotrad, BHODT, DHOTRAD versus the Board of Directors, appellate authority and others, ILR 2006, KER Karnataka, KER 3163. Put that number one, you write. HS Gotla, GOTLA versus state, IRR 2001, Karnataka KR 2843. Then this VN Gotla would be second. And Srimati Prey, PREY, Kyora, KHYORA, Yang RIYANG versus the state of AP and others, WPC 611 of 2016, decided on 26/6/2023. The next paragraph, the second ground lodged by the London Council for the petitioner is that on notice of the proceedings being served on the petitioner, he had appeared pursuant to notice of the proceedings dated 12/12/2022 on and on 19/12/2022, the petitioner paid for providing him with the written complaint filed with the complainant. However, by the same application, he also requested for allowing him to settle the matter amicably within the family. However, mail order was passed on 10/1/2023 and again on 24/1/2023 by the Additional Deputy Commissioner Papum Pare, which could not lead to settlement of the disputes. However, again on 8/5/2023, the petitioner once again read before the Additional Deputy Commissioner within bracket in charge for a copy of the complaint and other informations as mentioned therein, which is available in Annexure 10 to this writ petition. However, copies thereof were not served. The copy of the written complaint was not served on the petitioner. The third ground of challenge is that the that inquiry was ordered behind the back of the allegedly behind the back of the petitioner Where is that report? Where is that report? Report is not there.
No, 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 no.
Okay.
Not given to me.
Which
Nothing.
is referred to in the cancellation order dated 17, impugned cancellation order dated 17/5/2023. And it is submitted that without any application of mine, comma, only on the basis of the inquiry report, comma, the LPCs of the petition was cancelled. Next paragraph. The per contract from the government advocate has submitted that pursuant to order dated 5/12/2023, she had made an endeavor to obtain instructions, but she has been only provided with a copy of a page containing signature of the petitioner on 4/5/2023 to show that the petitioner had participated in the proceedings. He prays for some more time to obtain relevant records. Next, per contract from the learned counsel for respondent number 5 has submitted that the issues raised in this petition are disputed questions of fact which cannot be gone into by a writ court. So it is also submitted that there are justifiable grounds for cancellation of the LPC. 2 LPCs issued to the petitioner as the NOCs entitling the petitioner to be granted with the LPCs were obtained by misrepresentation and fraud. And it is also submitted that at the relevant point of time, when the LPCs were issued in favor of the petitioner, comma, the respondent number 5 and other siblings were minors. And that it is claimed that the petitioner took advantage of their minority to usurp their property. Next, it is further submitted that against every order that is passed in excess of origin jurisdiction under the Arunachal Pradesh, within bracket Land Settlement and Records bracket closed Act 2000, comma, section 83 thereof provides for appeal against every original order, and that the period of limitation is prescribed under section 84 of the said Act. Accordingly, it is submitted that the writ petition should not be entertained by this court. Anything I have left out? Have I left out anything? So you gave the citation. In support of the submission that disputed questions of fact ought not to be adjudicated in under Article 226 of the Constitution of India, reliance is placed on the case of New Okhla, OKHLA, Industrial Development Authority versus Kendriya Karamchari, KARAMCHARI, Sahkari, SAHKARI, Grih, GRIH, Nirman Samiti. It's here. This petition is here. Comma, within bracket 2006, bracket was 9 SCC 524. Next one. Having
There's also one citation, regarding when institute provide for appeal, if petition is not maintained. On citation 2010.
Just write it down and give it.
My lord.
And so and so. Yes, Madam. In respect to the first point raised, that an in charge officer can only do the day-to-day work and cannot undertake activities which are otherwise statutory duties. With all respect to the citations provided by the learned counsel of the petitioner, this court is unable to accept the said legal proposition for the reasons which are assigned hereunder. Next paragraph. From the text of the decision rendered in the case of B and Dhotra, DHOTRAD, which is like a Supra, we find that there is a reference made to the provisions of section 32 and 68 of the Karnataka Civil Services Rules. The copy of the said rules, is available in the internet, refers to notification number, notification issued under number FD gap 53-C full stop O full stop D full stop 58, dated 1st March 1958. And the said rules has been made in excess of power under proviso to Article 309 of the Constitution of India. Full stop. Rule 32 and 68, based on which the said judgment was rendered, are extracted below. From the herein before referred provisions of the said rules, it is apparent that that Rule 32 permits the government to appoint a person to be in charge of the current duties of a vacant post, which is in lieu of appointing a government servant to officiate. Therefore, Rule 32 of the Karnataka rules allows persons to be appointed as in charge only for the current duties of a vacant post. The tenure of powers commencing from below 2 months, comma 2 months, 3 months, and 4 months. Permit the officer to be appointed with full powers. Rule 68. Next paragraph, Rule 68. Also refers to appointment of a person as in charge of the current duties, inverted commas, of the current duties, inverted comma closed, of in office in addition to his own duties. And it is also provided that sanction of the government should be obtained where the in charge arrangement is proposed to be continued beyond 6 months. Full stop. No, nothing is placed before this court to show that the state of Arunachal Pradesh has a parameteria provision which limits an in charge to work to render service limited to the work of current duties. Full stop. Therefore, the court is of the considered opinion that that when it is referring to in charge of current duties, the Karnataka High Court was perhaps correct in its interpretation of the current duties, inverted comma, current duties, so as to exclude discharge of statutory functions. Full stop. Therefore, when the provision of the Karnataka Civil Service Rules, specifically section 32 and rule 32 and 68 were interpreted to exclude statutory function from that of inverted commas current duties. Current duties, comma, the said learned court was interpreting the said provision and gave its interpretation to the extent of the said rule 32 and 68, whereas this court has no material to show that the in charge ADC had no power to adjudicate the dispute which was placed before him in accordance with law. Next paragraph. Therefore, for the reasons assigned above, the court is of the considered opinion that the reliance of the said case of B.N. Dhotra in Supra by the learned single judge of single judge in WBC 611 of 2016 is otherwise distinguishable under the facts in which they said D.N. Dhotra, which is Becker Supra, was authored. Next paragraph. Nonetheless, when it comes to the ratio of stare decisis, STRA, DECIS, or law of precedent, this court would otherwise be bound by the decision of the learned single judge in the rendered in the case of Srimati Prey, Kyura, KHYURA, Riyang, RIYNG. However, as this court has assigned reasons for not accepting this ratio in the context of state of Arunachal Pradesh, it is deemed appropriate that the issue as to whether an in-charge officer in the state of Arunachal Pradesh can limit its functions to inverted commas current duties, or it may have power to do to discharge substantive duty, statutory duty, is perhaps an issue which requires to be decided by a larger bench. So accordingly, only in respect of the nature of duties that can be performed by a in-charge officer in the state of Arunachal Pradesh may be placed before Honorable the Chief Justice to examine the matter, and if it is deemed appropriate, the matter be referred to a larger bench for adjudicating the issue. Next paragraph. Be that as it may, for the reasons assigned above, as parameter provision of section 30 of rule 32 and rule 68 of the Karnataka rules are not found applicable in the present case. This court is of the considered opinion that by disturbing the order impugned herein only on the ground of the officer being in charge would lead to a ripple effect, which may have cascading effect on all administrative all orders that might have been passed in exercise of statutory duties, statutory provisions. This court, with all respect to the decision of this court in case of Srimati Ray Korarian, disagrees with the said proposition and therefore is not applied in the present case in hand. Next paragraph. Insofar as the case of HS Kotla, GOTLA, in bracket Supra is concerned, the same relates to power of investigation by an officer not below the rank of Superintendent of Police in cases under Prevention of Corruption Act 1947. It is in the said context of empowering investigation that the learned single judge of Karnataka High Court had interpreted that in charge Superintendent of Police would not get his in charge Superintendent of Police. No, that the Superintendent of Police was in charge of Superintendent of Police was merely being placed as an in charge, and he continued to have his rank of Deputy Superintendent of Police. And it is in the said context it was held that the Deputy Superintendent of Police is below the rank of Superintendent of Police. So the said issue cannot be interpreted to mean that even when in discharge of civil duties, when an officer is made an in charge, would lose his authority to pass appropriate orders which law otherwise requires him to discharge. Therefore, the case of H.S. Gotla within bracket Supra is also not found to help the petitioner in this case. Next paragraph. The second point raised by the counsel for the petitioner was, what was the second point? Second point was not, I forgot. What was the second point? What was the second point?
That, so, my lord, this second point, my lord, this no principal violation of natural justice, my lord.
No. In my order, what I've written.
So for maintainability, my lord.
Huh?
Maintainability.
I don't know, I've forgotten. First point, then second point.
First ground authority, second, my lord, none following the principle of natural justice, my lord. Third, my lord, at the behest of some other person, third party.
That is your ground, but I have already said that. Initial submission, number 1 to 3. The order, Impleadment order has been challenged on the ground that there is first, then second. Now, there is first, second. Oh, okay. So on the second point formulated by this court, it is seen that on initially appearing before the court of ADC, Balijan, the petitioner, right? Petition dated 19/12/2022 made a request for supplying him with a copy of written complaint. He said there his font had been reiterated by the petitioner before the additional deputy commissioner within bracket in charge, Balijan, by petition filed on 8/5/2023. First of therefore, the court is inclined to take a preliminary expressy view that from the date of appearance, on 19/12/2022 till 8/5/2023, the petitioner was not served with a copy of the written complaint. Nonetheless, it appears from the Impleadment order dated 17/5/2023 that the ADC in charge Balijan had ordered an inquiry, had appointed an inquiry officer, and on the basis of this said report, the respondent number 3 had cancelled the LPCs. For sake of convenience, the cancellation order is extracted below, page 23. From the above, it appears that the learned that the respondent number 3, sorry, no, it will be 4, not 3, 4. Respondent number 4 merely referred to the inquiry report and had cancelled the LPC without applying its judicial mind. It is not discernible from the set Impleadment cancellation order as to what was the basis on which the LPCs were cancelled. Full stop. Therefore, especially the order of cancellation of the LPCs is found to be quite questionable. And then the third point, what was the third point? Inquiry. In respect to the third point, raised by the Learned Counsel for the petitioner, the court is of the considered opinion that if at the instance of the court, a report is made by an inquiry officer, it would partake a character of a report of the commissioner as provided under Rule 9 and 10 of the Order 26 of the Code of Civil Procedure, and under the CPC, the said report becomes a part of evidence. Full stop. Therefore, in the present case in hand, it expressly appears that even before the copy of the written complaint was provided, that the inquiry report has come into record without even a copy of the written complaint being served on the petitioner. So therefore, an evidence is created before granting opportunity to the petitioner to rebut the allegations. Full stop. Next paragraph. Review. And on considering that all the concerned respondent number 5 have entered appearance, the court is of the considered opinion that as provisions for appeal has been provided for against orders passed by the additional deputy commissioner, under section 80 of the Arunachal Pradesh Land Management, Land Settlement and Records Act 2000, and there is no dispute at the bar by the learned counsel for the learned government advocate as well as the learned counsel for respondent number 5 that power to cancel LPC emanates from the said act. The court is of the considered opinion that instead of keeping the matter pending for adjudication in this writ court, it would be appropriate to relegate the parties to the appropriate appellate forum as provided under the said act. Nonetheless, as there has been an inordinate delay, as by the time the petitioner approaches the appellate forum, there would be some delay. Therefore, having noted that the said act does not provide for period of extension or limitation, and it cannot be said that Section 5 of the Limitation Act would have application in such cases or appeals, as this order has been passed without hearing without giving an opportunity to the Advocate General to address the court. The court is of the considered opinion that without treating this order to be a precedent, it would meet the ends of justice to relegate the petitioner to approach the appellate forum and on such application such appeal being filed, the appellate forum shall entertain the appeal without dismissing it on the ground of being barred by limitation, and give the opportunity of hearing to the aggrieved petitioner as well as the respondent of 5 hearing or any other person who may be affected by the cancellation of, on whose instance the LPCs of the petitioner has been cancelled. Next paragraph. The only issue is, which remains to be addressed is as to whether the impugned order is liable to be interfered with. So in this regard, the court finds that explicitly the petitioner has been able to make out a case for a case that he has not been given an opportunity of hearing. So therefore, the court is inclined to provide that the order of cancellation of the LPCs by impugned order number so and so dated 17/5/2023 by the passed by the ADC within bracket in charge Balijan, the said order shall be subject to any further order that may be passed in the appellate proceedings. Therefore, not only the petitioner but the respondent number 5 are also restrained from creating any third-party rights or to dispose of the any part of the land involved in the LPCs referred in the impugned order dated 17/5/2023 without leave of the concerned appellate court. First of this order shall be operative for a period of 21 days from today, so as to enable the petitioner to approach the appellate court. And on such appeal being filed, it will be open to the appellate court of the forum to pass such appropriate orders as it may deemed fit and proper under the facts and circumstances of the case. Next paragraph. Before parting with the records, it would be appropriate to mention here that this court has not embarked on the adjudication of any disputed question of fact. The only dispute raised before this court was that the order under challenge was passed without giving an opportunity to the petitioner of being heard, by providing him with a copy of the complaint petition, and that evidence in form of a report was created without his participation in the proceedings by filing a written objection. Full stop. Therefore, the cases cited by the learned counsel for respondent number 5 would have no application under the facts and circumstances of the case. More so, when this court has relegated the petitioner to approach the appellate authority to agitate his grievance against the order impugned. Order dated 17/5/2023 impugned hearing. Accordingly, with the observations as made indicated here in this request is closed, giving liberty to the petitioner to approach the appellate forum within the time as indicated above. Next paragraph. In order to expedite the resolution of the disputes raised by the petitioner, the court is inclined to dispose of the petition at the motion stage without issuing of notice on the respondents.
Deeply applied.
Deeply applied.
Next time that the copy of this order be placed before Honorable the Chief Justice.
Your Lordship, my apologies for the inconvenience caused to
This
this
copy
court.
of the orders, you will get it tomorrow.
We have served a copy upon.
Yes. Yes. Mr. Saikia.
My lord. My lord, in the writ petition, my lord, they have challenged the WT message, my lord, which was in fact issued to my lord OC, my lord, SP, my lord, Lordship can see at page 111, my lord, is always in my lord. My lord, this, my lord, WT message is preceded by an order of the court, my lord, commission, my lord. That they have not, my lord, annexed in the writ petition, neither that was challenged in the.
Show the order.
And in fact, and in fact, on that proceeding, my lord, the PIO of the, my lord, university was also, has appeared, my lord. This is a proceeding of, my lord, held on 2011-2023, my lord. May I read, my lord? Related to AP case number such and such, both parties found present during the hearing. After hearing both parties, it is felt that the PIO or the dean of the Apex Professional University Patia should take initiative to assist the appellants Ninia Angu and Sagri Takab in the university premises and sit together in computer system, and they need to log in together and show the particular information asked by the appellant. The appellant reported to the commission that they will not allow to enter into a university campus by the university authority. So appellant Sri Sajata requested the commission to pass order for permission to enter into the campus of the state university with escort. So the commission directed the SP, Isyang and OC police station, Arunachal Pradesh to escort my lord, to accompany the appellant my lord. Only for my lord entering into the premises my lord. They are my lord.
It destroys the academic, it destroys the academic environment if you allow police to enter a school or a university campus.
This is another aspect, my lord. The question is that, my lord, if they are agreed by this my order, they should have put this order to challenge, my lord. And there, my lord, in the paragraph, my lord,
yes.
My lord, in paragraph also will kindly see, my lord, paragraph 21 onwards, my lord. They have not at all, my lord, said about the, my lord, the order dated 2011-2023, my lord. In fact, my lord, they appeared before the commission, my lord. May I read, my lord?
Yes.
Paragraph 21 onwards, my lord. That the state commission exercises power under right to information and access powers are circumscribed by the act. The procedure followed by the commission while passing the interim order dated such and WT message, my lord. And they have completely, my lord, not mentioned the 2011-2023. And my lord, from paragraph 21 onward, my lord, and paragraph 27, my lord, the petitioner.
Can you tell me this is a original proceedings or it is a enforcement proceeding?
Well, it's an original proceeding, my lord, of the
original proceeding under the this RTI Act. Please show me what is the power of the commission.
The powers of the commission is section 18, lordship.
Section
18, lordship.
18.
Lordship, if I may submit, lordship.
Because Mr. Saike, if they are inherent powers, you see in a case, let us say in a writ petition, you are the petitioner. You forget that you are here, you are this side, you are the petitioner. You want a record tomorrow. There's some urgency in the matter. So if we have inherent jurisdiction, we will send the police, get the document seized from Department A, Department B, Department C, and bring it here. Because I know if I communicate it to the government advocate, Ms. Pangu will take some time to communicate, because by the time today at 4 o'clock when I am passing the order, by the time my secretary transcribes and brings it to me, it will be 5:30. So at 5:30, I know that Ms. Pangu won't be able to serve it because the officers would have left by now. So therefore, I have no alternative. If you want a record tomorrow, I have inherent power. I will send police, I will send army to go to the office, break it open, get the record and bring it here. No, I'm just thinking aloud. I'm not doing it. I'm just thinking aloud. If I have inherent power, what would I do with that power? To every department, I will send police. Can an information commission have that much of power?
Well, absolutely not, madam. Here, madam, only for the purpose of entering the, madam, appellant.
No, why? You see, there's an exemption. In this order, it does not say that the exemption under 8E and 8G does not apply. And therefore, you reject it, and you have the power to ask them to provide information. Where do you get the power that the information commission will send police?
No, police was not sent to assess the, madam, information, madam.
No.
For the purpose
You see, a third party can go and inspect my records. Therefore, today what we will do is that you see a hacker of the bank accounts. He will not operate from remote villages. He'll come to the information commission that I want to go to bank and just name the most well-to-do lawyer here. Supposing I assume you to be a most well-to-do lawyer. He says that I want to access his bank account, and therefore please send police to assist me in opening the bank account of Mr. Saikia in the bank. He doesn't go to dark web to hack your bank account. He does it legally. He says that in Mr. Saikia's account, I believe there is an unaccounted money, and therefore I have a right to information. Now please give me assistance of police to go to bank, operate his bank account, and to find out that unauthorized entry in that account. So the police does not do that investigation. Third party, he gets an access to the computer of a bank. In APSC cases, why you are sending police to make inquiry? Why you are appointing a commission to make an inquiry? You ask the police to go into this, into that XYZ. There is no need of a warrant. Notice to produce, even under the CRPC, for the purpose of the police to go search, there is a procedure. He has to take permission from magistrate to get a warrant issued and then go there. So this police is taking somebody in without a warrant to have unlimited access to the computer of the university. Don't know if that is permissible. We'll stay that operation. Due to paucity of time, I will dictate this in chambers.
Lordship.
Uh,
All right, Lordship.
This copy of order, I'll make it a part of the order.
Lordship.
You can get that copy. But the order may not be uploaded today.
Lordship.
It may be uploaded only tomorrow. But
Lordship, the government.
government advocate,
may be
you are here.
directed to
I have to request you to
communicate to the
to
OC.
communicate it to the Superintendent of Police, East Siang, and officer in charge of Pasighat Police Station to refrain from complying with the order dated 20/11/2023. Just take a dictation. But Mr. M. Das, counsel for the petitioner, is G. Leonard. Government advocate, additional senior government advocate. Your designation is additional senior government advocate. Additional senior government advocate, appearing for respondent number 1. Only 1.
1 and 6.
1 and 6. And Mr. R. Saikia Leonard, standing counsel for the State Information Commission, appearing for respondent numbers 2 and 3.
2 and 3.
Next paragraph.
2 and 3.
This court, by an order passed today, has interfered with the where is that WT message? Which
Page 117, Lordship. 111. 110 is the original. Annexure 22, page
111.
110, Lordship, is the original copy. 111 is the type copy.
With the impugned WT message. Issued by the dated 22/11/2023, issued by the registrar, deputy registrar, Arunachal Pradesh Information Commission under number capital APIC-764/2023/179. Stop. This order was dictated at 4 p.m. today, and therefore there is every likelihood that within the court working hours, the transcription of the order cannot be made. Stop. Next, therefore, the London government and additional senior government advocate is requested to transmit this supplementary order to the Superintendent of Police Pasighat, to number 1, Superintendent of Police Pasighat, number 2, officer in charge of Police Station, Pasighat, East Siang District, to refrain from complying with the directions contained in the said WT message dated 22/11/2023. In other words, the police personnel under the Superintendent of Police Pasighat are ordered to refrain from entering into the university campus of Apex Professional University Pasighat pursuant to the said WT message dated 22/11/2023 was passed, which was issued pursuant to order of the Arunachal Pradesh State Arunachal Pradesh Information Commission, Itanagar on 20/11/2023. The Court shall provide a copy of the said order to the learned additional senior government advocate. These orders are also online. Moreover, the learned additional senior government advocate is also at liberty to send a downloaded copy of this order, the supplementary order, to the said to police authorities as mentioned herein before. You can go and type this, call someone else. Type this order first. You can go. I'll call the second secretary.
Lordship is fixing a next date in the matter, Lordship. Lordship is fixing a next date in the matter.
Yes, next date. We'll have to give, suggest a date.
Another matter is also
Yes, Lordship.
connected matter. Then the matter will fix along together with that.
Lordship.
Please go to the.
Lordship, that is page 107, Lordship.
One,
Your name?
just within the, when is the date fixed?
Yes, Lordship. Order nikala sir na? Page 107, Lordship.
Page, you give me the date when it is
Lordship.
fixed.
Lordship, in this case, no notice, no date has been fixed, Lordship. It is WBC 273 of 2023.
WPC
It was last listed on
273.
273 of 2023. 273 of 2023.
So we list it when?
Lordship, that will be somewhere in the month of January, Lordship. After, Lordship, can it be on 22nd of January?
And 19 of course, 20. 20.
Fix it on 5th or 8th, whenever you want.
5th or 8th. It will be on 8th, Lordship, then.
8th.
8th of January.
Next date will be 8.
Lordship.
No, this is that yesterday's matter.
Lordship, the next date of the commission is also fixed on it, Lordship, may stay the proceedings, Lordship, in the meantime.
No, that proceeding we are not staying. You enter into you.
Lordship, because the question of jurisdiction of the tribunal of the commission, as well as whether the college, university is a public authority under the act, is also under challenge in the other petition.
Okay.
That matter would be considered on the next date matter.
Which one?
Matter regarding the jurisdictional issue matter.
That's what I'm saying. The
Immediately matter, this matter.
No, till 8th, when we are fixing, that proceeding should not go on. You see, he has challenged the jurisdiction of the commission.
Lordship.
So let till 8th, do not, we are not, we are merely saying that till 8th, that proceeding should not be taken up. Actually, yesterday we had passed some orders.
Lordship. Lordship, in fact, stayed the proceeding also yesterday.
Yes, yesterday the matter came up, we passed an order, but you were not there, so we deemed it appropriate to list it today. So if you can transcribe that order, then the supplementary order will not be issued. Then we'll give the entire order.
Lordship.
Correct?
Lordship. Obliged, Lordship.
Next date matter for admission matter, admission here.
For?
No,
This
Lordship,
matter, on
notices,
next date matter.
notices have to go to the private respondents, Lordship. There are two private
notices-
respondents. Notices have to go to them.
This will go to chamber.
And deeply obliged, my lord.
May it please, Lord. My lord, we want to withdraw and file application
appropriate application, man. Wrongly or rightly, man, we are challenging a revisional order of the learned sessions code, man. So it won't be appropriate to file under 401. So therefore, we want to withdraw.
Otherwise, also, your lordship, this petition is not maintainable because they are assailing the order of the session court, which has cancelled the bail. And they are assailing the cancellation order passed by the session court. In exercise of revisional jurisdiction, the session court has exercised the power. However, your lordship, the order, bail order, whether cancellation or rejection or allowing the bail order, is a purely an interlocutory order, your lordship. So if it is interlocutory in order,
439(2).
yes, your lordship. Because
It will be at the same court.
Your lordship, sorry.
It will be at the same court.
Your lordship,
The power is exercised by the same court.
no, your lordship, under 439 subsection 2, the session court as well as the high court has the jurisdiction to cancel the bail because the bail was initially granted by the judicial magistrate first class. And they have assailed the order passed by the learned court below, saying that, your lordship, the offense under which the offense was booked, section is booked, is punishable for life. And under section 437 subsection 1, there is a bar as such. Because the reason has to be assigned by the learned court below while granting the bail. The same was not done on a cryptic manner, your lordship, because for the investigation purpose, the custodial interrogation was not required. On that context, your lordship, the bail was granted. And the other side, since they agreed by the order of the learned JMFC court, they have the aggrieved party has approached the session court, invoking, your lordship, 397 read with section 439 subsection 2.
399.
Sorry, 399 and 439 subsection 2 also. So 439(2), your lordship, for section 439(2), the nomenclature would be criminal miscellaneous application, your lordship, for cancellation of bail. But on revisional jurisdiction, by discussing the 497 jurisdiction, the learned court below has interfered the order passed by the learned court below, which by exercising the revisional jurisdiction, which they have assailed before this honorable court, invoking revision only, your lordship. Which revision is not at all permissible because it will amounting to second revision only, which is not permissible under criminal procedure, your lordship.
Therefore, we are filing appropriate application by withdrawing this.
Otherwise, your lordship has rightly pointed out.
No, you see, there is another issue which has come up. That is why in the morning I did not permit that. You see, cancellation of bail is normally under 429(2).
Yes, your lordship.
Correct. Now, if the court registers it as a revision,
yes, your lordship,
it's a question of lack of jurisdiction. If it's a lack of jurisdiction, why this court cannot invoke the revisional jurisdiction and interfere with the order? That is one part, because that is not entertaining a order on merit. That is one part. Second is that we can otherwise say, or because you see now, let us check the position. The Sessions Court has passed an order.
Yes, sir.
It becomes functus officio. So against in an application under 439(2), it cannot enter in a second application under 439(2). So what is his remedy?
482, your lordship.
482, we have.
482.
Yes, your lordship.
So therefore, for that, why you want to withdraw it and?
Yes, I think it would be appropriate, so that it looks bad, we have already drafted and filed, this way.
Okay. Mr. P. Tokudan, counsel for the petitioner, and Mr.
T at the, your lordship.
T.
At the ETE. Yes, sir.
Learned APP have been heard on the prayer made by the learned counsel for the petitioner to withdraw this application and to approach this court under section 482 CRP.
Yes, madam.
The said prayer is allowed. This matter stands closed on withdrawal with liberty to the petitioner to
oblige me.
propose this court in an appropriate jurisdiction.
Deeply obliged, your lordship.
Yes.
My lord. My lord, here, my lord. NIT, my lord, NIT, it was floated on 3rd October 2023, my lord. Page 25 is NIT, my lord. Notice inviting tender, my lord. Pursuant to this NIT, my lord. Issue dated, my lord. Pursuant to this
What is the
NIT.
fictitious ground on which you're?
My lord, see at page 27, my lord. This result was notified only on 4th December, my lord. Day for yesterday, my lord. Serial number 7 is my lord.
Yes,
MS
rejected technical.
Rejected technical. My lord, the remark is, my lord, 11.1 of the appendix to
1.1.
ITB.
1.1.
Yes, 1.1 of the appendix to ITB and clause 6.1 of the part 1 of general condition of
Let
contract.
us see that clause
My
1.1.
lord, you see at page 32, my lord.
32.
Page 32, yes. Page 32, my lord, you see appendix to ITB, point 1.5, my lord.
32.
Employer. Page 32, my lord. Employer is EE/PI, PIU, RW, Likabali, Lower Siang District. So on, so my lord.
Where is your tender? To whom you have submitted the tender?
My lord.
Who is the tendering authority? If it is
Tendering
not
authority, my lord, EE.
E.
Yes, my lord.
What did you do?
It is there, my lord. Now, just since it has been quoted, that's why, my lord, just the reference has made that employer is EE, executive engineer concerned. Now, my lord, second clause is clause 6.1, my lord, of general condition of contract, my lord. It starts from page 34, my lord. Page 34, relevant page is at, my lord, page 37, my lord. General condition of contract, page 37, clause 6.1, my lord. It starts from page 34. Relevant clause at page 37, my lord, 6.1, my lord. All certificate notice instruction to be given to the contractor by the employer engineering shall be sent on the address or contract detail given by the contractor in section 6 form bid, my lord. Section 6 form bid, my lord, you see at next page, at page 38, my lord. This is a format, my lord. This is to be furnished, uploaded by the bidder, my lord. This is the format, and this format, my lord, you see at page 40, my lord. I've extracted, I uploaded this as per this format, my lord. Employer name EE as per the clause 1.1 of appendix to ITB, my lord. Detail, my lord. Now, this the remarks they've given for a ground for rejection, it is absolutely, my lord, non-existence, my lord.
Yes. Mr. Ratan.
My lord, I think my learned friend's client has not pursued the tender very diligently. There was an corrigendum in the change of the name of employer, which he might have missed out. And this was notified in the e-portal as well as the corrigendum I'm submitting.
And what about 1.1?
Corrigendum, let both.
Show it to him also.
That has never been, my lord.
No, that has been also uploaded in the e-portal, the corrigendum regarding the change of the name of the employer.
My lord, you see, this is
corrigendum and
my lord, you see, this document was only uploaded on 5th December, yesterday, my lord.
Oh, this is downloaded.
No.
This is not. This was
No.
9th of
No, that is only shown, only unless it's online, man. Unless it is uploaded, it is automatically generated, man. Once it's uploaded, my lord, it will imprint automatically that, my lord.
The publication date is written here.
My lord, it is now, my lord, see, in uploaded in web portal, if they modify and keep it under the table, my lord, that how it will be known to us. Now the encrypted, my lord, it is on record, it cannot be tampered with by anyone, my lord. Now this document, it is uploaded, my lord, you see at 5th December, yesterday, my lord.
No.
This is encrypted.
No. That is not. That is
the
date is downloaded one. The corrigendum that was uploaded, you'll see the timing here.
No.
Uploaded
9th October, 1:25 p.m.
Yes. Published date. Correction of name if my lord will say, corrigendum documents detail, number one, correction in the name of employer and validation of non-judicial stamp paper. 9th October 2023, 1:25 p.m. Corrigendum uploaded. This is there.
My lord, this has never been made public, man.
My lord, that's why I was saying that diligently he has not pursued the. Otherwise, in the impugn order itself, others have rectified.
No, other only my lord, 2 farms out of 10, my lord, only 2 farms.
That's why at least 2.
And my lord, this should have been even well sitting, my lord, pre-bid meeting, my lord. This should have been known, my lord, made known. My lord, it is just written as a published date, my actual uploaded, my lord, you see in online tender, my lord. It is automatically generated, my lord. No, this will not.
This is the
No.
published date.
It is only written.
No,
Now, how will show that it has been
given here.
uploaded on the, because my lord, online tender, my lord, whatever he upload, it will automatically imprint, my lord.
This
Auto
page
generation.
was
No.
Just a moment.
this
just a moment.
particular page was
Give me-
downloaded yesterday.
I'm looking at something. Give me 5 minutes.
Yes. This particular page was downloaded yesterday. That's why the time is given. The upload time is there.
This is not coming up. Can you find out for us?
My lord, I believe for entering here, the bidders, they need their key.
That is called digital signature certificate. My lord, it automatically, whenever it upload, my lord, it is automatically imprint, my lord. Also, my lord, at page 31, my
Whatever
lord, how
document is uploaded, the time is also given, my lord. That's why.
My lord,
No, you have to show us. You can call your officer here tomorrow.
my lord,
No,
My
Mr.
lord,
Ratan.
can you see that,
Mr. Ratan,
yes, ma'am.
call the officer either tomorrow or day after tomorrow in the court. Let him open it for us and let me see it.
Yes,
It was
sir.
uploaded.
That also, otherwise also, my lord will see corrigendum document details, correction in the name, published date, and the time also is given. If my lord will see time, 1:25 p.m.
On 9:10.
my lord,
And then the second document, 3rd October, 10:39 p.m. These are the exact time when it is uploaded in the website.
my lord will see my page 31, my lord. How the digital signature, how it affect, how it imprint the date, my lord, even time, my lord. Also, my lord, page 31, my lord, last column, validity unknown, my lord. My lord, see, this is how it's done, my lord. Digitally signed by so-and-so, person who has signed, and date, my lord, year and month, date, my lord. That's 23 November 30, my lord, date. Particular date, my lord. This is how it is authenticated, my lord. This is generally, my lord, in online, It cannot be tampered with, my lord. Whenever a document is uploaded, it's automatically imprint, automatic. It's auto-generate system, my lord. But if somebody just putting the date in backdated, my lord, upload, my lord, how it is not possible. It should be transparent, my lord.
You see, that's why we are saying, because you see, these correspondence details are there, publishing date, the details are given. Now it is only to be seen that if I open it tomorrow in court, if this date of 5/12
yes,
changes to 7/12 tomorrow, then that means this is the downloading date. It
Yes,
cannot be
this is the
uploading date.
downloaded one.
Ask somebody to be here. I just wanted to
Yes,
see
yes.
the uploading. and
Otherwise
publishing.
also, in page 30, my lord, we'll see, if this was uploaded only yesterday, at page 30 of the impugn order, my lord, there are other bidders who have been rejected, not in this ground, different grounds. The serial number
No,
one.
that is okay. That is beyond the.
Yes,
besides the
serial
point.
number one and this 7 has
You
been,
ask your officer to come here with the key
yes, my lord,
and to open the
and
portal
to demonstrate,
to demonstrate here.
yes, my lord.
We will permit them to use this computer and.
Yes, my lord. Otherwise, there is nothing, this has been downloaded on our instructions.
Okay.
Xerox, okay.
Heard Mr. T. Tagum, legal counsel for the petitioner, as well as I have to rise.
my lord.
I cannot take up any other matter because there is a
My lord.
there is a meeting at 4:30. Heard Mr. T. Tagum, legal counsel for the petitioner, and Mr. Luan, sorry, R. N. Ratan, additional
AG.
Advocate General for the state, appearing for the respondents. At the outset, it is submitted that the correction of the name of employer was uploaded and published in the e-procurement system for PMGSY on 9/10/2023, for which a printout has been provided to the court. Full stop. The next para, although the date of publication is mentioned as 9/10/2023, but in the document, the a date of 05-DEC-2023, then a gap 05-26 PM is mentioned. Full stop. Therefore, comma, in order to dispel the apprehension of the court, comma, the court is inclined to direct the competent authority of the respondents,
Yes, my lord.
who is empowered with the key to open the portal.
Yes.
The present.
Any of officer who can demonstrate, my lord.
Oh, that's why.
Because,
Who is having the key and is in a position to demonstrate before the court, the
Yes.
uploading date. Shall be personally present in court
on,
tomorrow is.
my lord, this is from Likhavali. Tomorrow, day after tomorrow, if, my lord.
Day after tomorrow. Okay.
Yes, my lord.
Day after tomorrow is 8th. 8/12/2023 at 10:30 AM, at 10:15 AM. Correct?
Yes.
10:15 AM. First of- Next, the action of the technical bit of the petitioner shall be subject to further orders that may be passed on the said date.
Deeply obliged.
Obliged.
Go, let's go. I will not be able to tell the court master because there is a meeting at 4:30.
For tomorrow, because this is, okay.
Tomorrow, I don't know whether it can be listed or not, but just tell the court master.